or BIFF, have pledged allegiance to ISIS. These rebels seek to establish a wilaya, or Islamic province in Mindanao, in memory of the brave Filipino soldiers who sacrificed their lives to recover most of Marawi and stop the rebels from turning it into a wilaya. I respectfully request a moment of silence to honor their heroic efforts to protect Philippine sovereignty. The crisis in Marawi City began in the early afternoon of May 23, 2017, when a deadly encounter erupted between the government troops and the Maute Group. The Maute Group unleashed terror and havoc in the peaceful city of Marawi. They took over Marawi and in the process, burning government facilities, desecrated churches, and causing massive dislocation of Marawi residents and deaths among troops and civilians. Responding swiftly to the incident, President Rodrigo Roa Duterte issued Proclamation Number 216, declaring a state of martial law and suspending the privilege of the writ of habeas corpus in the whole of Mindanao, pursuant to Section 18, Article 7 of the 1987 Constitution. Were it not for the President's swift and decisive action in declaring martial law and suspending the privilege of the writ of habeas corpus, the rebels could have established a stronghold at the heart of Mindanao. On May 25, 2017, President Duterte submitted the report relative to Proclamation Number 216 to the Congress. Senate President Aquilino Pimentel III and Speaker of the House, Pantaleon Alvarez, received the report at 2155 hours. Both houses of the Congress, acting separately, discussed the President's report and decided that no joint session of the Senate and the House of Representatives was necessary. The Congress also made it known that there was no compelling reason to revoke Proclamation Number 216. It must be emphasized that Congress has no duty or authority to affirm the declaration of martial law, as it only has the power to revoke or extend martial law. Martial law is valid and takes effect without need of any concurrence by Congress. The petitioners have initiated the present proceedings under the third paragraph of Section 18, Article 7 of the 1987 Constitution to review the sufficiency of the factual basis of Proclamation Number 216 and nullify it for utter lack of sufficient factual basis. This Honorable Court is now called upon to resolve the issues arising from the consolidated cases. Let me discuss the procedural issues first. At the outset, it must be pointed out that the petitions pending before this Honorable Court suffer from a number of defects, to name a few. Number one, the failure of Petitioner Erice to sign the verification and certification of non-forum shopping page, which defect was also noted by this Honorable Court. Number two, the professional tax receipt number of Petitioner's Counsel is already outdated as it was obtained on August 16, 2016. Number three, irregularities in the notarial certification of the verification and CNFS. And number four, failure of Attorney Monsod to disclose his MCLE compliance number or MCLE exemption number. The sheer number of defects reveal that petitioners' total disregard of the rules of court. This should not be countenanced by this Honorable Court. In fact, we have filed a motion to dismiss, Your Honors. On this standard of review, the petition is fatally flawed because it was not filed under any of the remedies provided under the rules of court. The Constitution specifies that martial law be questioned in an appropriate proceeding. It is not enough for the petitioners to just declare that they have initiated the proceedings under the third paragraph of Section 18, Article 7 of the 1987 Constitution. They must specify the remedy they used in filing the petition. Section 18, Article 7 of the 1987 Constitution allows judicial review of the proclamation of martial law or suspension of the privilege of writ of habeas corpus, but limits the review to the sufficiency of the factual basis behind it. Contrary to the assertions in the Muhammad and Kulyamat petitions, Section 18, Article 7 does not make the review of the sufficiency of factual basis mandatory on the Supreme Court. The provision is very clear in its terms, and I quote, "The Supreme Court may review the sufficiency of the factual basis of the proclamation of martial law," unquote. The word "may" imposes no obligation, but merely gives the Supreme Court the discretion whether to give due course to the petition. If this honorable court is minded to exercise its power of judicial review, notwithstanding the preceding defects, it has to take into consideration the following facts. The power to declare martial law is inherent in the President as the Commander-in-Chief. Despite the safeguards found in the present Constitution, the President as Commander-in-Chief continues to possess full discretion in declaring martial law and suspending the privilege of the writ of habeas corpus. Consistent with this principle of separation of powers, this discretion can only be corrected if it is attended with grave abuse. Otherwise stated, if there is sufficient factual basis for the proclamation of martial law and the suspension of the privilege of the writ of habeas corpus, then it cannot be said that the President acted with grave abuse of discretion. Grave abuse of discretion is the appropriate standard to judge a declaration of martial law for the following reasons. First, when the President and Congress act together in the use of their constitutionally bestowed powers, due deference should be given to the resulting action, which carry the weight and approval of two branches of government, the members of which had been duly elected by the Filipino people. The declaration of martial law and its support by Congress carry with them the imprimatur of the sovereign Filipino people. Second, the Supreme Court has original jurisdiction under Section 5, Article 8, over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Of these proceedings, it makes most sense that a petition for certiorari would be the, quote, appropriate proceeding, unquote, referred to in Section 18, Article 7, in order to ask the Supreme Court to nullify the implementation of any proclamation of martial law or suspension of the privilege of habeas corpus. The nullification of an act, after all, is the office of the writ of certiorari. Past government actions were reviewed by the Supreme Court through a certiorari proceeding pursuant to the second paragraph of Section 1, Article 8, which empowers the court to determine whether there was a grave abuse of discretion amounting to an excess or lack of jurisdiction on the part of government. Third, jurisprudence examines the exercise of Commander-in-Chief powers, including martial law powers, under the lens of grave abuse of discretion. In Lansang versus Garcia, the standard applied for determining propriety of the suspension of the writ of habeas corpus is whether the act had not been arbitrary and not whether it had been correct. The Honorable Court can review the factual basis for the proclamation of martial law and suspension of the privilege of the writ of habeas corpus, notwithstanding that Congress has already acted on and resolved to support the declaration of martial law. Given these considerations, the Court, if it does not peremptorily dismiss the petition on procedural grounds, should resolve the substantive issues through the standard of grave abuse of discretion and decide whether the petitioners have sufficiently established the basis to nullify Proclamation Number 216, which has already been upheld by the two houses of the Congress. I will now go on to the substantive issues of this petition. What is the actual issue of this case? In their prayer, petitioners seek to nullify Proclamation Number 216, alleging there is no insufficient factual basis. Jurisprudence, however, puts the burden on the petitioners, as it is incumbent upon them to show that the President's decision is totally bereft of factual basis. They who allege must prove the petitioners miserably failed to overcome this onus. We quote the words of this Honorable Court in the case of IBP versus Zamora. If the petitioner fails by way of proof to support the assertion that the President acted without factual basis, then this Court cannot undertake an independent investigation beyond the pleadings. Besides, the absence of textual standards that the Court may use to judge necessity, information necessary to arrive at such judgment might also prove unmanageable for the courts. Certain pertinent information might be difficult to verify or wholly unavailable to the courts. The history of ISIS and its connection to the terrorist groups in the Philippines. Martial law was declared in Mindanao by President Duterte because of the rebellion by terrorist groups led by the Maute and Abu Sayyaf groups. Martial law was not declared only because of the ongoing battle in Marawi City. The crisis in Marawi City is not an isolated incident, but part of a bigger plot to establish an Islamic State in Mindanao in accordance with the call of ISIS. By way of background, a discussion must be made regarding the Islamic State in Iraq and Syria, or ISIS, otherwise known as ISIL, Islamic State in Iraq and Levant, or simply called Islamic State or IS, or its Arabic language acronym Daesh. It is because of this jihadist proto-state that we now face this tragedy in Mindanao. The Philippines has its own share of ISIS-linked terrorist groups. One of them is the Abu Sayyaf group, whose faction in Basilan is led by Isnilon Hapilon. Hapilon and 40 others ASG members swore allegiance to ISIS and al-Baghdadi in a video posted on YouTube on July 23, 2014. Hapilon has been appointed by ISIS as the emir or leader of all Islamic State forces in the Philippines. The ASG has now taken steps to reinforce his position and take advantage of the recognition and support of ISIS. Recently, Hapilon and his followers were under pressure from continued military operations in Basilan. He needed to flee to the mainlands of Mindanao, but his travel to the mainland had another purpose. It was a symbolic hijra or pilgrimage to unite with the ISIS-inspired terrorist groups in Mindanao, which is a step to establishing the Wilaya or Islamic province. The establishment of wilaya would signify secession from the Philippine Republic. Thus, Hapilon went to central Mindanao to link up with the other terrorist groups like the Maote Group. The Maote Group, which also calls itself Daula Islamia, was founded by Omar and Abdullah Maote, the eldest of the Maote brothers. Prior to their allegiance to ISIS and its extremist ideology, they were known as an extortion gang and a private armed group. After setting in the mainland of Mindanao, Hapilon lost no time in issuing a call to arms for all ISIS-linked groups to unite and stage violent attacks, and they have answered his call. In the months leading to the siege of Marawi City, there has been an escalation of terrorist acts. Number one, there have been a series of improvised explosive device attacks in the Zamboanga, Basilan, Sulo, Tawi-Tawi area. Number two, on September 2, 2016, there was a bombing of the night market in Davao City perpetrated by the Maote Group. Number three, in Marawi City, members of the Maote Group ambushed military elements on February 16, 2016, attacking Major Jericho Mangalos and one other enlisted personnel. Number four, in Maguindanao, BIFF elements liquidated Corporal Joarcin Baliwan, Staff Sergeant Saldi Kaliman, and Corporal Makadatar in separate incidents in February and April 2017. 7 military personnel stationed in detachments in Maguindanao were likewise wounded by BIFF elements. All of these terrorist acts taken together further the rebellion being undertaken by the ISIS-linked groups in Mindanao. As pointed out by President Duterte in his report to Congress, these activities constitute not simply a display of force, but a clear attempt to establish the group's seat of power in Marawi City for their planned establishment of a Daesh wilaya or province covering the entire Mindanao. Moreover, the cutting of vital lines for transportation and power, the recruitment of young Muslims to further expand their ranks and strengthen their force, the armed consolidation of their members throughout Marawi City, the decimation of a segment of the city throughout city population who resist, and the brazen display of Daesh flags, the one I showed you, constitute a clear, pronounced, and unmistakable intent to remove Marawi City and eventually the rest of Mindanao from its allegiance to the government. President Duterte further went on to state that there exists no doubt that lawless armed groups are attempting to deprive the president of his power, authority, and prerogatives within Marawi City as a precedent to spreading their control over the entire Mindanao in an attempt to undermine his control over executive departments, bureaus, and offices in the area, defeat his mandate to ensure that all laws are faithfully executed, and remove his supervisory powers over local governments. Contrary to the petitioner's allegation, the Marawi siege was not merely a, quote, government-initiated armed conflict, unquote, but a joint operation of the PNP and the AFP that actually preempted and foiled the plan of the terrorists to burn down the city of Marawi and establish a wilaya. Hapilon's leadership consolidated the 4 insurgent groups in Mindanao, namely the Basilan-based ASG, the AKP, the Maote Group, and the BIFF, and solidified these terrorist rebels' ties with ISIS. These terrorist elements, whose previous terrorist acts were separate and uncoordinated, are now openly under one leadership and are in outright rebellion against the government. As a matter of fact, the petitioners themselves have admitted in their suit that the first element of rebellion is present in this case. There is a public uprising against the government and their bearing arms. As regards to the other elements, Hapnilon and his cohorts have shown by their actions that they intend to remove from the allegiance to the government parts of Philippine territory, starting with Marawi. It is under this milieu that the joint operations of the AFP and PNP to arrest Hapilon should be understood. The authorities were not just arresting a mere criminal, but the head of a terrorist rebel organization seeking to establish an ISIS province in Mindanao. The rebels planned to burn down the city of Marawi on the day of Ramadan on May 26, 2017. The joint PNP-AFP operations raid of their safe house 3 days prior to this date actually preempted the carefully laid out plan and forced the rebels to prematurely initiate the siege of Marawi. The siege of Marawi is the most recent offensive launched by the rebels. The intention of the rebel group is to make the siege a rallying cry of their rebellion and signal all their allied terrorist groups to simultaneously stage their own violent uprisings all across Mindanao so as to attain their aim of establishing the wilaya. Armed men rampaged through the streets of Marawi and swiftly occupied strategic positions throughout the city. Snipers positioned themselves atop buildings and began shooting at government troops. This prevented certain establishments, such as the Amay Pakpak Medical Center, they entered certain establishments, such as the Amay Palpak Center, to have their wounded treated, then moved on to the city jail and the land bank of the Philippines. They burned Dansalan College. They spared no one, killing even teachers and other civilians. The rebels seized Marawi not for the purpose of raid and pillage. They did not just intend to strike fear into the hearts of the populace. It was a coordinated act of an organized group against the government. They wanted to establish a caliphate and dismember Marawi from the republic. They took over the city and set up roadblocks. They staged a power blackout throughout the whole city, resulting in the total collapse of the local government and the shutdown of local courts. The rebels were able to take control of major social, economic, and political institutions of Marawi City, leading to its complete paralysis. One of the keys to the success of the rebels' assault was their mastery of the urban terrain in Marawi City. It allowed them to freely and swiftly move about the city and gave them the advantage of accurately predicting where government troops were coming from, thereby improving their defenses. The rebels were equipped with a large arsenal of military hardware, including rocket-propelled grenades that can destroy tanks. They also possess vast amount of ammunition for high-powered assault rifles. Military operations are continuing to end the rebellion being waged by Hapilon, the Maute group, and their cohorts. It is not an easy task. Because of its location and topography, Marawi City is easily accessible to other parts of Mindanao, making quelling the rebellion difficult. The place is a strategic starting point for the rebels to lay the groundwork for their ultimate objective, which is to gain control and establish a wilaya in Mindanao. Although the rebels may have initiated the rebellious activities in Marawi, it does not necessarily mean that Marawi is the culmination of their plans. The extensive network and linkages of the Maute group with foreign and local armed groups, as well as their continued alliance with other terrorist groups, are strong indications of their intention to expand their operations beyond Marawi City. The seeds of rebellion were already planted in different parts of Mindanao. Public safety requires that the declaration of martial law and the suspension of the privilege of the writ of habeas corpus be made to apply to the entire region of Mindanao and not just to Marawi City. Being associated with the ASG, the Maote Group undoubtedly enjoys support in other parts of Mindanao. The group has launched attacks in other parts of Mindanao, more particularly in Davao. Moreover, there are two other ISIS-linked local rebels, the AKP and the BIFF, which are waging attacks in other areas of Mindanao. Hence, placing the whole Mindanao under martial law and suspending the privilege of the writ of habeas corpus thereat was a logical step for the President. Any scheme to tie his hands will render the government unable to suppress and ultimately put an end to the rebellion in the whole of Mindanao. Upon the declaration of martial law, the military was ordered to destroy the ISIS-linked rebellion of the Maote Group and the local terrorist groups, including Isnilon, Hapilon. After 20 days of combat operation, the high-value targets and most of the members of the Maote Group were contained in Marawi City. Beginning May 23, 2017, a total of 232 rebels were neutralized and 134 high-powered firearms and 19 low-powered were recovered from them. 4 ISIS flags were recovered, along with 79 million in cash and checks. These gains, however, came at a high cost. On the part of government forces, as of now, 61 of our brave soldiers and policemen died, and 289 were left wounded. With the immediate declaration of martial law, the grand plan of the Maote Group to take over Marawi City and extend it to entire Mindanao to establish a wilayat was preempted. The declaration of martial law and the suspension of the privilege of habeas corpus rendered the Maote Group and ASG Group incapable of conducting further hostilities and spreading extremist violence. Normalcy is now being restored. The armed hostilities, as mentioned and narrated in the President's report to Congress and Proclamation number 216, indubitably show that there is sufficient factual basis for the declaration of martial law and the suspension of the privilege of the writ of habeas corpus in the Mindanao Group of Islands. Indeed, the armed hostilities between the Maote Group, the ASG, and other terrorist rebel groups on one hand, and the government forces on the other, as described in these two presidential issuances, undoubtedly point to the existence of rebellion which gravely endangers public safety. All the elements of rebellion were present when the President issued Proclamation number 216. Proclamation number 216 and the President's report to Congress narrate the public and armed uprising in Marawi City on May 23, 2017, aimed at removing the allegiance of Marawi to the government and depriving the President of his powers and prerogatives to enforce the laws of the land, not only in Marawi City, but in the rest of Mindanao. The gravamen of the crime of rebellion is an armed public uprising against the government. The facts, as mentioned in Proclamation number 216 and the President's report to Congress, show that as of May 23, 2017, when the President declared martial law and suspended the privilege of the writ of habeas corpus in the Mindanao region, rebellion indeed existed. The President's report also provided a more detailed picture of the uprising and the motivation behind it to establish a Daesh wilaya in Mindanao with Marawi City as the armed group's seat of power. The petitioners erroneously relied on public statements by the military as reported by media in order to question the factual basis of the declaration of martial law. What they failed to consider is that the conflict is real, and some of these statements could have been made as a form of psychological warfare or psy-war. The fact is that there is a rebellion and there are ongoing operations to halt it. It cannot be gainsaid that the sufficiency of the factual basis for martial law proclamation should be examined from the point of view of the sole decision maker, the President, and at the time he exercised this discretion. This full discretion granted to the President by the Constitution includes the authority to make conclusions of fact and conclusions of law to declare martial law. These conclusions are made at the time he made the decision. Section 18 of Article 7 limits the scope of judicial review to the sufficiency of the factual basis of the proclamation of martial law and the suspension of the privilege of the writ of habeas corpus or the extension thereof. This means that the President is required to take account only the situation at the time of the proclamation, even if subsequent events may not have been accurately reported. Extending the basis to facts established or discovered after the proclamation unnecessarily subjects the President's discretion to an unrealistic standard. He is only expected to make decisions based on information available to him before the decision is made. Petitioners argue that Proclamation number 216 is void for vagueness because it includes the broad term other rebel groups. We submit that the identity of all rebel groups is irrelevant in determining the sufficiency of the factual basis for martial law. Besides, Proclamation number 26 makes reference to Proclamation number 55, which in turn cites Abu Sayyaf as another rebel group. The President's full discretion in the exercise of his Commander-in-Chief powers. It is beyond dispute that the President's exercise of power as Commander-in-Chief to call out the military to prevent or suppress lawless violence or to declare martial law should be swift and decisive if it is to have any effect at all. Furthermore, the Constitution bestows the full authority to proclaim martial law upon the President and no one else, and without need for the prior approval of any other public official, much less his alter ego. The recommendation of the Secretary of National Defense or any member of the Executive Department for that matter is not a condition precedent to the President's exercise of his power to proclaim martial law or suspend the privilege of the writ of habeas corpus. Consequently, the absence of such positive recommendation does not affect the validity of Proclamation number 216. Neither does it impact on the sufficiency of the factual basis for its proclamation. Neither does the Constitution provide a need for calibration in the exercise of these Commander-in-Chief powers. The issue of which power the President should exercise is beyond the power of the Honorable Court to dictate. It is submitted that calibrating the graduated powers inherent in the President as the Commander-in-Chief under the guise of judicial review would amount to the Court replacing the President's exercise of discretion with its own. The President had already used his calling out powers last September 4, 2016, when he issued Proclamation number 5, due to then increasing concerted attacks against the military and the populace. The use of calling out power, however, could no longer address the ongoing rebellion. That is why martial law was declared by virtue of Proclamation number 216. The Constitution under Section 18 of Article 7 gives the President full discretion to choose which among his Commander-in-Chief powers should be used given the circumstances. In other words, the use of calling out power is not a condition precedent to the proclamation of martial law. Neither is the latter a condition precedent to the suspension of the privilege of the writ of habeas corpus. There is no sequential requirement for the use of these powers, as Section 18 of Article 7 only provides for the requirements before they may be used. The validity of the President's use of his calling out powers under Proclamation 55, series of 2016, is independent of the validity of the declaration of martial law under Proclamation number 216, series of 2017. Declaring Proclamation number 216 as unconstitutional, if that is the case, will not affect the validity of Proclamation number 25. Nonetheless, given the gravity of the situation, a more expansive authority is needed by the President to fully engage the rebellion of these terrorist groups in Mindanao. The exigencies of the times require that the President should at least be given the flexibility to act in the interest of public safety. Such flexibility should not be any cause for worry. President Duterte's declaration and implementation of martial law is markedly different from that of former President Marcos. In his General Order Number 1, dated May 30, 2017, President Duterte directed the martial law administrator and the martial law implementer to observe the limits of authority prescribed under the Constitution, the laws, as well as the rules and regulations. President Duterte likewise ordered that the constitutional rights of the Filipino people be respected and protected at all times. He even called the Commission on Human Rights to assist the protection of the citizens' constitutional and human rights. The Department of National Defense also established a citizens' assistant desk where senior lawyers from the Public Attorney's Office have been made available to assist citizens with human rights complaints. This highlights the government's goal of preventing human rights abuses that have been previously associated with martial law. Your Honors, these are trying times. We are at a war with an enemy that does not respect the laws and principles we live by. We are at a war with an enemy that seeks to destroy our way of life and force its twisted ideology upon our people. Its goal is to take over Philippine territory and establish a caliphate in Mindanao in allegiance with ISIS cohorts who continue to sow terror worldwide. Already, there are casualties to our military and police who are trying their best to protect our citizens. Civilians have been brutally murdered. Our people have been forced to flee from their homes and seek refuge from the atrocities committed by these rebels. These attacks by the rebels do not only occur in Marawi, but also in other parts of Mindanao. The fight against these rebels will be long and arduous. The government cannot allow our country to be the next battleground in the war of terror. It cannot sit idly by and watch as the country is dismembered. It cannot allow fear and intolerance to be the new normal in this nation. We ask that this court permit the government to make use of all the tools granted to it by the Constitution. Among these tools is the President's power to declare martial law in times of invasion and rebellion when the public safety requires it. Martial law is seen by some as a draconian measure, but it is a measure granted to the President by our Constitution. These are extraordinary times. They require extraordinary measures. Affirming Proclamation number 216 will help the government end this rebellion, bring the rebels before the bar of justice, and procure stability and lasting peace in Mindanao. Thank you, and mabuhay ang Pilipinas.
Thank you, Mr. Solicitor General. We will begin our interpellations with Justice Del Castillo.
Thank you, Madam Chief Justice. Good afternoon, Solgen.
Good afternoon, Your Honor.
There is a difference between the calling out powers of the President and his martial law powers, correct?
Yes, Your Honor, there's a nuance of difference, but these are tools given to the President under our Constitution to defend the integrity of our nation, Your Honor.
this morning, a position was taken that there is basically no difference except for the fact that in martial law, there is focus or ascendancy of the commander-in-chief powers of the president. Now, can you please enlighten us on what you think are the differences between these two powers of the president?
Well, if, according to the petitioners, if they are the same, then why did the framers of the Constitution place two remedies or tools of the president to address rebellion or invasion when public safety requires it? So the nuance is that martial law is proclaimed by the president, who has the sole authority to determine it, if in his reasonable belief the threat or danger is very imminent already. And there is actual rebellion already in the streets of Marawi. And actually there was, because, Your Honors, the proclamation was signed around 11 o'clock, if I'm not mistaken. But the hostilities occurred at around 2 p.m. in the afternoon. So when he saw that the rebels were getting stronger and stronger, and in fact they were rampaging the streets of Marawi City, and having proclaimed Proclamation 55 a year ago, this is the calling out of the armed forces to suppress the state of lawlessness, in his reasonable belief, and he alone could decide this, martial law was the proper tool that he would use to address this situation.
That's my question. What in the power of martial law is not in the power of calling out the armed forces that made the president decide that at this particular situation, martial law has to be proclaimed?
Well,
What is so fearsome about martial law? That's what people are, they don't know. They're
Yes.
so afraid of
Right.
what is in there that is not in the calling out powers. Because my next question to you is, why could the president not have just called out the armed forces to quell the rebellion?
well, technically speaking, Your Honor, there was the Proclamation 55 was still existent at that time. But when he saw the gravity of the rebellion, he had to act decisively and swiftly, and therefore he chose the martial law tool to save Marawi from total capture by the rebels, Your Honor. So, but I do not understand why the petitioners are afraid of the martial law imposed by President Duterte. There's not much difference to it, actually.
Is it your position that the calling out powers of the president could not have solved the problem? Could not have handled the situation? Could not have quelled the brewing rebellion?
I will not talk about my judgment, Your Honor, but in the President's judgment, martial law was the necessary tool that he should use in the light of the events that happened when he was considering what tools he will use, Your Honor.
Anyway, you mentioned about the president deciding to proclaim martial law to preempt the Mauti rebels and its followers from burning Marawi, from taking siege of Marawi, and establishing the ISIS state there. What exactly precipitated the president's declaration of martial law?
He was in Russia during that time, Your Honor, but he was constantly being fed with the developments in the Philippines. He has access to all intelligence reports, Your Honor. Now, when it was already growing dark, And there were casualties already, and there were Maote group as well as the other terrorists freely roaming the streets of Marawi, and they were burning establishments. He had to use martial law in accordance with his judgment, Your Honor, because the Constitution gives him that power and prerogative.
You mentioned that the President was in Russia for a state visit.
Yes, Your Honor.
Whom do you think fed him with this information about the situation in Marawi?
As I said, Your Honor, he continuously monitors intelligence reports. Our President is very conscious about national security, Your Honor.
Would you say
That's why he was able to protect Davao from falling to the rebels.
Would you say it was his military advisors who were with him?
Not
Or some
necessarily, Your
cabinet?
Honor. Not necessarily. He has access to local or even international intelligence reports, Your Honor.
The way the war has waged on, it would seem that the Maute rebels are well prepared.
Yes, Your Honor.
They seem, their arms, their ammunition seem to be inexhaustible.
Yes, Your Honor.
And there was one time where several millions of pesos was recovered
Yes,
from
Your
a
Honor.
hideout. It takes time to have done what they did. And I'm surprised why the military never discovered all this, the preparations that went into it. Why did it have to reach this point where practically the military was taken by surprise? You were trying to arrest, you were saying, Isnilon, and to prevent that, the Maute rebels had to make their act.
Well, let me put it this way, Your Honor. In fact, in one of our annexes, there's a video there that shows how the Maute group and Isnilon Hapilon planned to attack Marawi. And the plan was that by Ramadan, May 26, they would raise Marawi City. When the military got wind of the info that Isnilon Hapilon was in Marawi City, that's when they organized this group, the AFP and PNP, to arrest Isnilon Hapilon. However, they were met with superior force, and suddenly there were snipers. They were pre-positioned already, Your Honors. That's why our troops suffered casualty. So they had to regroup.
That's what I'm saying. Apparently, the Maute rebels were well prepared. How is it that our military, it's a total failure of intelligence? Don't you think, Solskjaer?
Intelligence gathering is not perfect, Your Honor. It's like a jigsaw puzzle. There are certain parts of the puzzle that are not yet clear. But one thing is clear, the military knew that Hapilon was already in Marawi City, and that's why they went there to arrest him, because they got wind also of his plans. The intelligence knows that there are already 4 ISIS-linked rebel groups that I mentioned in my opening statement, Your Honor. So this would be the Marawi City among Muslims is like the capital of an Arabic state, Your Honor, because there's the universities, the place is very suitable also. It is in the heartland of Mindanao, and there are many roads leading to Marawi City. So that's why Isnilon Hapilon considered this as a pilgrimage he will establish the ISIS province not in Basilan, but in the heart of Moroland. This is Marawi.
Now, assuming that the president was justified in declaring martial law in Marawi, why the entire Mindanao?
Because as I said in my opening statement, there are already linkages in other parts of Mindanao, Your Honor, like the Ansarul Khilafah Philippines, AKP, the BIFF, and of course the Abu Sayyaf from Basilan. and
But
parts of
Soljen, I was listening to Justice Marbic's interpellation yesterday, and he was mentioning several places, which to me, I think are peaceful places. Why include all these other provinces to be under martial law also? What we're worried is it might just embolden the president to later on also include Manila, Luzon,
No, Your Honor, no.
the Visayas, and then Luzon. So the entire Philippines. So there's this concern also. So why the entire Mindanao?
Because of the plan of the ISIS-linked groups, Your Honor, to make Mindanao a caliphate, whose allegiance is to the Caliph of ISIS, al-Baghdadi, Your Honor.
Thank you, Counsel.
Thank you,
Chief.
Your Honor.
Justice Carpio.
Counsel,
Good afternoon, Your
good
Honor.
afternoon, Counsel. You earlier said that there is not much difference between the martial law powers of the President and his calling out powers under the present Constitution. Not much difference. Now, let's be more precise. When you say not much difference, there's still a difference.
Yes, Your
What
Honor.
is that difference?
It's like a sentence. Instead of a period, there's an exclamation point, Your Honor.
Yeah, but what is
Or
that?
calling out in steroids, if
But-
I may use a...
But in terms of powers, what are the powers acquired by the President under martial law compared to the powers that he will acquire under the calling out power? I mean, we're talking here about legal powers.
Yes,
I mean,
Your
we're not talking about exclamation points.
Yes, Your Honor. Well, if I may say it, the calling out powers is the milder form, Your Honor, milder form.
Yeah, but in terms of actual power of the President, can he do something under martial law powers that he cannot do under the calling out powers?
Suspension of the writ of habeas corpus. Martial law will
Yes.
suspend the writ of habeas corpus.
Well, Your Honor, if he chooses the tool of martial law, he can also suspend the writ of the privilege of habeas corpus as public safety
Yeah.
requires it.
But let's not talk about that because he may or may not suspend. I'm saying what is the difference between the calling out powers and the martial law without suspending the writ? What would be the difference? Because the President can suspend separately the writ, so let's take that out first. No, okay, I'll help you out. Let's go to section 18.
Okay.
The fourth paragraph. It says, a state of martial law does not suspend the operation of the Constitution. So, that's clear. The Constitution is not suspended, nor supplant the functioning of the civil courts or the legislative assemblies. nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function. Then you see a little difference. So if the civil courts are able to function in Marawi City, there can be no military tribunals that will try civilians because it says it does not authorize the conferment of jurisdiction. But when the Constitution says does not authorize the conferment of jurisdiction, jurisdiction is conferred by law, correct?
Yes, Your Honor.
So this is really a power given to the Congress. If the civil courts are not able to function, then Congress can authorize the conferment of jurisdiction on military tribunals to try civilians, correct? But
Yes.
there has to be a law, and
Yes,
we
sir.
don't have a law right now.
Correct.
So Congress may, if they want, pass a law saying that in Marawi, because the civilian courts are not able to function, military tribunals can try civilians. But it's a power given to Congress.
Yes,
It's not
Your
a power given to the president, correct? So it does not also automatically suspend the privilege of the writ. So what would be the difference really? It's hard to think of a difference, correct? Okay, let's go to arrest order number 2. In arrest order number 2, you have a list of people who are supposed to be arrested. And it says, in connection with their having been identified as members, supporters, spies, couriers of the Maute Group, Abu Sayyaf, etc. Okay. Let us say that here is a Maute armed fighter. He drops his gun and escapes to Iligan. He's now in Iligan City. Can he be arrested for
Well,
rebellion?
Well, Your Honor, the crime of rebellion is a continuing offense, and the fact that he dropped his rifle doesn't mean he has left the rebellion, Your Honor.
Okay, so it's a continuing crime, and therefore, whether he has dropped his weapon or not, he can be arrested wherever he is.
He can be captured, Your Honor.
He can be captured, arrested because he has already dropped his weapons, is mingling with the civilians now. So he will be arrested, and that's a valid arrest, correct?
Yes, Your Honor.
Because it's a continuing arrest. Even if no crime was committed in the presence of a police officer, he did not do anything that's criminal aside from the rebellion, he can be arrested, correct?
Yes, Your
because
Honor.
rebellion is a continuing crime.
Correct, Your Honor.
Even if you are in the hospital being treated, you can still be arrested.
Yes, Your Honor.
Okay, there was a case where somebody in the hospital was arrested, correct? A rebel.
Yes, Your Honor.
So, but that is not because of the declaration of martial law. I mean, that will apply whether martial law is declared or not. A rebellion is always a continuing crime, correct? So if you are an NPA, armed fighter, you get wounded, you go to a hospital, you're treated there, you don't have weapon, you can still be arrested, correct? Because rebellion is a continuing crime.
Correct, Your Honor.
So what does the martial law powers give the president actually?
Like what I said, Your Honor, it's
Psychological.
psychological probably. It's an exclamation point.
Gulpe de gulat.
Yes, Your Honor. So you better listen to me now because I'm imposing martial law.
Yeah, but can you talk that way to the Maute Group? You know, the president, the Maute Group threatened to burn Marawi a few months ago, and the president said, go ahead.
Well, these are,
They will not listen. They will not be frightened.
well, some may be frightened, Your Honor, but the hardcore will not be frightened because they believe that if they die, they will go to heaven and will be gifted with 72 virgins, Your Honor.
Okay, you said that there has to be a reason for martial law to have been included in the Constitution, aside from calling out powers. So, would you say that martial law under the present constitution means that civilian authority has collapsed and military rule will govern.
No, Your Honor.
It will not mean.
Will not.
Because the Constitution says it does not suspend the operation of the Constitution.
Correct, Your Honor.
So there is really no way to infer that new powers are acquired by the President under martial law, correct?
Well, I see your point, Your Honor.
So I think, would you say we better educate our people that martial law really does not give the President any new powers that he does not already possess before the declaration of martial law, and there's nothing to fear?
Coming from a prestigious justice like you, Your Honor, that will help in the...
Yeah, but I saw there in that general implementing order that they are threatening the media. I think that will not help.
That of the AFP will define it. In martial law, it's not all civilian.
Okay. I'm sorry, Your Honor, please.
Yeah, is there anything there? Okay,
Well,
so in martial law, if the writ is suspended, then you have something else, correct? If
Yes.
the President suspends the writ of habeas corpus, what is the meaning of that?
Well, when there is a petitioner who goes to court and asks for a writ of habeas corpus, the court will still function and issue the writ, but if it is related to the crime of rebellion, etc., then
He will not be released.
he will not release it, Your Honor.
So it's just like any other crime.
Yes,
If you go to the court for habeas corpus, the court will order the production of the person.
Yes, Your
and if
Honor.
it turns out that he is being detained legally under an arrest for maybe murder, then he cannot be released also, correct?
Correct, Your
It's still
Honor.
the same. So there's really no difference. Okay, let's go to another point, Counsel. Let's go to proclamation number 216. 1, 2, 3, 4, the fifth whereas clause. Whereas today, 23rd May 2017, the same Maute terrorist group, etc., thereby openly attempting to remove from the allegiance of the Philippine government this part of Mindanao. Attempting to remove from the allegiance of the Philippine government this part of Mindanao. What part of Mindanao was referred to? Marawi City, correct?
From the context, yes. Yes,
So,
Your Honor.
the proclamation of President Duterte declaring martial law refers to the Maute group attempting to remove Marawi from Philippine territory to establish their Islamic State, correct?
That was really their grand plan, Your
Yes,
Honor.
but it refers to that part of Mindanao, only Marawi City. It's there in the proclamation itself, correct?
In this particular whereas, yes, Your Honor.
Okay. So, let us, rebellion has to be actual, correct, for martial law to be declared.
Yes, Your Honor.
Okay. Is there any report from the intelligence service or police or AFP that the Maute group has reached the Nagat Island province, that they have sent armed fighters there?
I am not aware of that, Your Honor, but I will ask the military intelligence, Your Honor.
How about Camiguin? Has there been reports that armed fighters of the Maute group has reached Camiguin Island?
I'm not in a position to say yes or no because I haven't.
Okay, can you just
Ask
put
me.
that in your memo? And
Yes, Your
also,
Honor. Yes, Your
Misamis provinces, several provinces, Misamis Oriental, Occidental.
Parts of Mindanao.
Yes, Your Honor. May I also point out, Your Honor, the subsequent whereas, it says here, the recent attacks shows the capability of the Maute group and other rebel groups to sow terror and caused death and damage to property not only in Lanao del Sur, but also in other parts of Mindanao.
Yes, Counsel. It says recent attacks. That means past. Shows the capability. Capability does not mean rebellion. As I said the other day, you have the intent to rebel, you have the capability, but you must have actual rebellion. So this one does not speak of actual rebellion. It speaks of capability. They have the capability to attack.
The only thing, Your Honor, that has changed the picture is that these other rebel terrorists or rebel groups, they have already subscribed allegiance to the ISIS.
Yes, but
Yes, Your Honor.
But we're talking here of actual rebellion. I'm trying to establish where in Mindanao was there a rebellion. And it looks like in Marawi, you can easily defend that there's rebellion. But outside of Marawi,
Huwag mo lang tanggalin.
I have not seen any evidence that there is actual rebellion in Dinagat Island, Camiguin Island, Misamis provinces, Agusan, Zamboanga, Davao, Surigao, Pagadian, so Dapitan. So all these places that I mentioned, can you please put in your memo if
Yes,
there
Your
are intelligence reports
Yes, Your Honor. And
that
besides,
there are rebels actually from the Maote group or even from other groups?
because there could be conspiracy also in rebellion. For instance, the financier is based in another place, or the cuddlers of these rebels, or those who were part of the plan. Your Honor, they can be arrested anywhere also, because the act of one is the
Yes.
act of all.
Yeah, they can be arrested, but whether there is actual rebellion in that place, because the Maote group can come here. Does it mean that there is already rebellion in Manila? No. But we can arrest them.
Because they are rebels, Your Honor.
Yeah, because they are
Yes.
rebellion is a continuing crime.
Yes,
But
Your
we
Honor.
don't have to declare martial law here to arrest them. But it doesn't mean that just because they temporarily sought refuge here, there is rebellion already. I mean, even if they come here, they send that an armed group to conduct assassinations, that's not still rebellion, correct? Terrorism is not rebellion, correct?
But it could lead to that, Your
Yes,
Honor.
it could lead, but it's not actual armed uprising.
Which group are we talking about here?
The Maote group,
Maote
assuming that
group.
they sent an assassination group here to assassinate some of the officials, it doesn't mean there's rebellion in Manila, correct?
Well, the rebellion follows the rebel, Your Honor.
For purposes of arrest, but
Yes,
for
Your Honor.
purposes of declaration of martial law, can the President now declare martial in Manila because they have sent a team of 5 people to assassinate the military heads here in Manila?
If there is a factual basis, then that will be the time, Your Honor. Sufficient factual basis. He
No,
can
I
now
mean, if
declare.
there's let us assume that they have sent here a team of 5 sharpshooters to assassinate the top 3 military leaders of the Philippines.
So if it is just assassination, Your Honor,
It's not rebellion.
yes, Your Honor.
Okay, so let's be clear on that. But they can be arrested the moment they are discovered here, correct?
Yes, Your Honor.
Because that is a continuing crime, the rebellion.
Correct, Your Honor.
Okay, so, well, that's all, Counsel. I just want you to put in your memo the acts of rebellion that could possibly cite in all the other places in Mindanao outside of Marawi City.
Yes, Your Honor.
Okay, thank you. That's all.
Thank you.
Justice Reyes.
Good afternoon, Solicitor
Good afternoon, Your Honor.
Kalida and everybody. The respondent's position is that President Duterte enjoys immunity from suit and should accordingly be dropped as respondent in the Kunjabat case. Is that correct?
The President enjoys immunity from suit. Yes, that's correct. Your Honor.
Would that be in conflict with your position that the petitions must be filed under Rule 65 of the Rules of Court because allegedly, according to you, the President, it must be proven that the President has committed grave abuse of discretion.
Yes, Your Honor, but that can be addressed also by Article 8, Section 1, Your Honor, and Section 5, if I'm correct.
Would we consider him as being sued in his official capacity and not in his personal capacity as President of the Republic of the Philippines?
He cannot be sued, Your Honor. I was surprised why one of the petitioners included the President Duterte.
Despite the
as
fact that
respondents.
you insist in your consolidated comment that grave abuse of discretion in accordance with Rule 65 must be applied.
Well, if they
that's
choose
applicable.
that remedy, then they will be covered by the rules of Rule 65. The problem with the petitioners, Your Honor, they did not tell this court what remedy, under what rule, what's the basis. They just cited Section 18 of Article 7. So the confusion comes from them, Your Honor, not from us.
But nonetheless, Mr. Counsel, considering the fact that this involve matters involving national interests, which covers not only these present generations, but will still cover the next generations, would it be proper not to dwell on procedural defects? Because you have mentioned that the petitions suffered from more or less about four procedural defects.
Yes, Your Honor.
So would you still insist on your comments for us to rule on the procedural aspects?
Well, these rules, Your Honor, came from the Supreme Court, and I'm a law-abiding lawyer. That's why even in our pleadings, we scrupulously observe all these requirements. They may be procedural, but we should respect the rules drafted by the Supreme Court. I have high regard for the Supreme Court, Your Honor. I don't know why they just take these things for granted, because it's just procedural.
Well, considering that these defects, as I have said, are procedural in character,
Yes, Your Honor.
and
Maybe they
the
should,
issues involve national interests.
but that is not an excuse to defy the Supreme Court's rules, Your Honor. Otherwise, every Tom, Dick, and Harry lawyers will just follow this precedent if we allow this to fester, Your Honor.
All right, let's go to another
Thank you, Your Honor.
topic. Section 18, Article 7 of the Constitution provides for the following powers of the President. Call out power. B, to declare martial law. And the suspension, and C, the suspension of the privilege of the writ of habeas corpus. So we agree on that, Mr. Counsel.
Yes, Your Honor.
There is no question about that. And would you enlighten us the difference or distinctions between the calling out power and the power to declare martial law on the part of the President?
Well, these are the commander-in-chief powers of the president, Your Honor, under our constitution. As I said in response to Justice Carpio's
Judge, this is
interpellation,
in consonance
I
with,
will
Justice Carpio,
probably
interpellation.
answer the same, Your Honor.
So that is your answer.
We will
Absolute
discuss
answer,
it
Mr.
in
Counsel.
our memorandum, Your Honor.
All right. Now, would it be less effective if the president exercises calling out power instead of declaring martial law? In other words, is it really necessary for the president to declare martial law in Mindanao? Can he not achieve the same effect if he just called out the armed forces to suppress the attack of the Mauti group in Marawi City?
Well, Your Honor, the Constitution vests the President that sole prerogative to determine which of the remedies or powers given to him by the Constitution he will apply. And in this particular case, since he had access to intelligence reports, and also since he monitored what was happening in Marawi, Your Honor, that was his judgment call, and I cannot argue with that, Your Honor.
So that is the perceptions of the president based on reports of the military.
Yes, Your Honor. And for me, that is a prejudicial question, Your Honor. I cannot question him on that.
Now, under Section 18, Article 7 of the Constitution, necessitates that there is an act of rebellion or invasion. Am I right?
Yes,
about
Your
that?
Honor.
You stated in your consolidated comment that the attack of the Maute group in Marawi constituted actual rebellion. Is that
Yes,
correct?
Your Honor, because all the elements of rebellion were present at the time the President decided to proclaim martial law.
So if the actual rebellion happened in Mindanao or in specifically in Marawi City, would it be why is it that the declarations of martial law covered the whole Mindanao?
That was his political judgment at that time, Your Honor. And since our President comes from Davao City and has been mayor for so many years, he knows the peace and order situation in Davao. He has been talking to all the rebels, all the other groups against the government. He has information that is not available to me or to anybody else, Your Honor. And therefore, I trust his judgment, Your Honor.
All right. As a follow-up question, the President issued the proclamation number 216 only hours after the Maute group launched in its attack in Marawi City. Am I correct?
I think about 9 hours after that, Your Honor.
So 9 hours.
And 9 hours is a long time when there is rebellion being waged, Your Honor.
All right. Thank you very much.
Thank you, Your Honor.
I have actually been very much enlightened by the new phrase that you have pronounced this afternoon, which is martial law. As you understand it, is the calling out powers on steroids.
Thank you, Your Honor.
Yeah, actually, it's very illuminating for me. Now, what are the side effects of taking steroids?
I don't know, Your Honor.
Sergeant
I haven't
Calida.
taken any.
Well, if you are going to look at the literature from the most reliable medical websites, they would include acne, blurred vision, cataracts, bruising, sleeping, high blood pressure, increased appetite, weight gain, increased growth of body hair. And for those with high blood sugar, your blood sugar level will even increase. But in all this literature, they also say that steroids do not address the ill.
Am I supposed to answer that, Your Honor?
Not yet.
Well, anyway.
But you can
Well,
think about the legal implications here. So, steroids actually give the appearance, of course, of increased muscular presence. It can give the appearance or the feeling of greater power and lesser inflammation in the areas that are being addressed. Now, this is in connection with my question, therefore. If it is important for us to be able to get the legal standards before martial law can be declared, we need to inoculate our armed forces from the possible idea that they are actually an armed forces on steroids.
Your Honor, please don't take my phraseology literally, Your Honor. It was just a figure of speech. Please don't take me seriously on that.
No, actually, it was very smart, Solgen. I really found that statement to be very smart.
Thank you, Your Honor.
And which means if this court is to exercise its power to review the factual basis, then it must be able to declare to the people the real parameters of the martial law powers and not just allow people to have a psychological high from martial law. In other words, we are here to help everyone, all the institutions of government, to understand what they are supposed to discharge or not discharge. So this is the context. What we are here looking for, Soldier, is really a legal standard, which is necessity. Necessity for the declaration of martial law before we can say that the martial law declaration, in fact, had sufficient factual basis. And necessity is a matter of fact and of law. So, in response to the question of Justice Carpio, you really said that it's calling out on steroids. So, in what sense, therefore, is the calling out powers amplified in a way that it could not have been amplified with the use of the original concept of calling out?
Your Honor, as far as I'm concerned, the standard for examining the sufficiency of factual basis was already in the Constitution, Your Honor. And I would like to believe that the lis mota of this case is whether or not President Rodrigo Roa Duterte had sufficient factual basis in proclaiming martial law and suspending the privilege of the writ of habeas corpus as stated in Proclamation number 216. That is the lis mota as far as I know, Your Honor.
Are you not forgetting the requirement of necessity? Because it comes with the same sentence when
Yes.
the public safety
Correct,
requires it.
Correct, Your Honor. You're right.
And when you are looking at Lansang as a model for reviewing how the court should examine the validity of the declaration, either of martial law or of the suspension of the privilege of writ of habeas corpus, you're actually talking about the framework of the old Constitution. The new Constitution has provisions there that were never contemplated in the 1935-73 Constitution. Am I correct?
Yes, Your Honor. In fact, in the Lansang versus Garcia case, you have to inquire merely the existence of the factual basis. But in our 1987 Constitution, sufficiency of factual basis. So
Plus-
that is the standard now, Your Honor.
Plus, again, Mr. Solicitor
Well,
General,
when public
necessity.
safety requires
That's why
it.
our questions must be more directed to the connection of the factual basis at a sufficient level necessary to establish the requirements of protecting public safety.
And when there is an actual rebellion, as what happened in May 23, necessarily public safety was endangered because of the activities of the rebel groups.
I actually took this approach, Solgen, of trying to assume the correctness of all of the factual assertions you had made in your comment. And when I go through the entire comment, the question remains, and I don't know, I want you to validate it, then why declare still martial law if the calling out powers were there? Why is it therefore necessary? Because necessity means you are in an extreme situation.
That is the judgment call of the President, Your Honor, because he alone was vested with his constitutional powers, Your Honor.
If you are saying that his judgment call is the only basis, then you are going to get this issue out of this court's review powers. In other words, we cannot at all question his judgment, but the Constitution requires us to review the factual basis for the necessity.
And that is the least mota of this case, Your Honor.
It's either the judgment call alone of the President, apart from anything that can be established by the court, or the court will go into an examination of the factual basis. Which is it, Mr. Solicitor General?
I'm sorry, Your Honor. Can you please
Okay.
repeat the question?
There are two propositions that are before us. You had actually said that that was the judgment call of the President. You are not going to prove to this court why it was necessary to declare martial law. That's one of his inherent powers. But the Constitution requires us to really examine the factual basis, if it's in sufficient form and if it's necessary for public safety. Either we look at the Constitution as it literally requires us to fulfill the duty, or we just say we will not fulfill this duty and we just defer to the judgment call of the President. What are you asking this court to do?
Well, as I said, Your Honor, the standard lies in the Constitution itself, the sufficiency of factual basis.
So it is, we need to establish and be able to declare that the factual basis was sufficient and it was necessary to declare martial law, and therefore Proclamation 216, because the public safety requires it, is therefore valid. Are you saying that?
Well, that is a political question in so far as the President is concerned, Your Honor, because he was given the full discretionary discretion.
Those two are incompatible positions. Either there is sufficient factual basis, which this court needs to examine,
Yes.
and in its decision, the court will already say that these are the factual basis which we have accepted. They are to such a sufficient degree, and the sufficiency is such that it is necessary for the President to declare martial law. And at the same, we cannot say at the same time that that is a political question. Those are two irreconcilable positions, Mr. Solicitor General.
May I be allowed to read this?
Yes, please.
Okay, it says here, Your Honor, Section 18, the Supreme Court may review, Your Honor, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law, or the suspension of the privilege of the writ, or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. So the Supreme Court, under this Section 18, is mandated to review only the sufficiency of the factual basis of the proclamation of martial law and not its necessity, Your Honor.
Again, can you again read it? If you read the sentence correctly, you mean they are disjointed? Public necessity is not necessity to protect public safety is not required?
May I read again?
Yes, please.
Okay. The Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ or the extension thereof, and must promulgate its decision thereon within 30 days from its filing, quote unquote. That's all that there is, Your Honor. There's nothing here said about necessity to impose martial law.
All right. Can you go back to the first paragraph? The President, okay, shall be the Commander-in-Chief of all the armed forces, and when it becomes necessary, etc. No? That's the calling out powers. That's the first sentence. Is that correct, Soljan? That's the first. Now let's go to the second sentence.
Yes, Your Honor.
Can you now go and look at the second sentence? In case of invasion or rebellion, when the public safety requires it. You mean simply because it is in the second sentence of the first paragraph of Section 18, we cannot review that anymore?
Well, let me read it in its entirety, Your Honor.
Okay.
In case of invasion or rebellion, when the public safety requires it, he may, referring to the President, Your Honor, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. So, this is from the point of view of the President, not the Supreme Court, Your Honor.
You mean the sufficiency, the degree of necessity is not part of the review powers of the court, only the factual basis?
Yes, in accordance with Section 18, Your Honor, of the Constitution. It's not my fault, Your Honor. I was not a member of the Constitutional Commission, but this is what the law, the Constitution says.
Is it not this? The sufficiency for the factual basis of the proclamation of martial law. And how does the President proclaim martial law? He must fulfill the two conditions in the second sentence. Is it not correct? The factual basis of the proclamation. In order to be a valid proclamation, it must satisfy the two conditions of the second sentence. Otherwise, the phrase of requirement of public safety is a completely inutile phrase.
Well,
because that is the only way that the proclamation can be valid, if it is required by public safety. And what we are going to review is the factual basis for the proclamation, for a valid proclamation.
Yes, Your Honor.
We don't have to always repeat the same exact phrase in the following paragraph. If there is a relationship of the second paragraph to the first paragraph, that is already what the court will connect. As far as the court is concerned, the second sentence of the first paragraph sets the conditions for the valid presidential proclamation. Now, with respect to the next paragraph, the appropriate proceeding where we are reviewing it, we have to relate it with the second sentence of the first paragraph. So we have to find out whether it was actually a necessity in order to protect public safety. And that is what we want to find out.
We will, in our memorandum, discuss these
Yes.
things, Your Honor.
Thank you very much.
Thank you, Your Honor.
If you have been saying that everything has been a political call of the President, his judgment, he did not need the recommendation of the defense and military officials, only he possesses the plenum of intelligence information that may not be available. Do you mean to say that in this particular area, the President's action is completely non-reviewable by the court?
Well, insofar as as I read, Your Honor, the Supreme Court may review in an appropriate proceeding, and I still believe that the petitioners did not apply the appropriate proceeding. Then the sufficiency of the factual basis will be the one that will be reviewed by this honorable court, Your Honor.
Okay. I have already assumed, for the purpose of this argument first, the correctness of all your factual assertions. And for the purpose of this questioning, I will not at all question anything in that regard.
Thank you,
But
Your
my
Honor.
first question is really, where have you shown us that it was necessary, a requirement of public safety for the President to declare martial law? And in your own view, in fact, the calling out powers is not very much different from the martial law powers. Now, I now go to the question and the statements you had been making about many judgment calls being outside of the review of the courts because only the President is cognizant of this information. Does this apply in this particular situation, Solicitor General?
Well, not only that the Constitution gave this power to the President, but Congress also supported it, Your Honor. There are now two independent branches, the executive and the Congress. They are agreed that the President, when he issued the martial law, was within his powers, Your Honor, and therefore Congress supported it. And Congress, the congressmen and the senators are elected by the sovereign people, including the President, Your Honor.
You know that very well, and in a proper time, we may need to discuss that quite intensively. But for now, let's just talk about what what Article 7, Section 18 requires as a duty on the part of the court.
Yes,
The political
Your Honor.
question doctrine has not seen life since the 1987 Constitution, except only in very, very limited circumstances. Mr. Solicitor General, you are aware of that, of course.
Maybe this is an opportune time to revisit it, Your Honor.
In fact, if you are going to look at the proceedings and many of the decisions of the Supreme Court, the call really is for the court to exercise the judicial power that has been given to the judiciary under Article 8, not in steroid version, but in real version. So, Mr. Solicitor General, what in this particular situation, how are you now justifying the resurgence of the political question doctrine, which to all constitutional historians and scholars was the principal mechanism by which the Supreme Court was blamed for having unduly validated Mr. Marcos' martial law?
Well, one thing I can assure you, Your Honor, President Duterte is not President Marcos.
Well, I know the names are very different already. That's quite obvious. But what we are saying here is that we are trying to establish legal standards. And you want us to go to a legal standard that has been much discredited already, which is the political question doctrine. You have asked us to defer to the two houses of Congress resolutions, to the President. Of course, all of those matters are very clear in our minds, and they will have their proper place in a proper situation. But you have asked us also to accept on faith what is the judgment call of the President, and it appears to us you are unable to present to us a legal standard by which the powers of this President in this particular instance should be examined. What we want is to find out whether there are legal standards that are applicable under the framework of the 1987 Constitution. Can you enlighten us and help us
Yes,
in
Your Honor.
addition to the arguments that you have already given us?
In page 23 of our consolidated comment, Your Honor, we set the standard for examining sufficiency of factual basis. It is arbitrariness, Your Honor, and not correctness.
In other words, as long as the President was not arbitrary
Yes.
in having declared martial law because he deemed it necessary to protect public interest in view of the existence of what you earlier considered as actual rebellion, then this court will have to uphold the declaration of martial law.
That's correct, Your Honor.
Now, in another part of Article 7, Section 18, the Constitution talks about the declaration of martial law in parts in the Philippines, whether in the entirety of the Philippines or in parts of the Philippines. How do we apply the legal standard for a valid proclamation of martial law to the entirety of Mindanao?
Again, Your Honor, it's arbitrariness, not correctness, Your Honor.
Okay, I have no further question. There are other justices who are going to ask. Justice De Castro, Bersamin, and then Justice Leonen. In that order, please.
Just want to make some, request some clarification. Earlier, there has been some issue raised about the difference between the calling out powers and the declaration of martial law. And there was an initial opinion advanced that there seems to be a little difference between the two. But I would like to venture into the difference between these two powers as mentioned in decided cases.
Yes, Your Honor.
In the calling out powers, this is more military in nature. It allows only the President to call the armed forces to take military measures or to take military action against certain groups. But in the case of the martial law powers of the President, the AFP is not only to be engaged in combat operation, but the AFP is engaged in the general maintenance of peace and order. That is why there is a requirement
Yes.
in the Constitution that there must be a need for public safety, which means that the AFP will be doing the function of ordinary peace officers in the community. So
That's
they
right,
will
Your
not
Honor.
only engage in military combat, which is what is called for in the power of the President to call the armed forces of the Philippines to suppress lawless violence, invasion, or rebellion. I think that's the difference between the two powers of the President in general.
Thank you. Thank you for that, Your Honor. Actually, that was what I had in mind when I said the martial law powers is like is on steroids, in the meaning to say it is the AFP that has the hardware. They have the tanks, they have the airplanes, they have these weapons of war that the PNP does not have. And so, since they are now called by the President under his martial law power to quell this rebellion, then we have a better chance of succeeding when the AFP is asked to to be in that area to preserve peace and order, rather than the PNP. The PNP are ill-equipped, Your Honor. They're not designed for war. It is the AFP.
The first power of the president is just to use the AFP in military operations
Yes,
to
Your Honor.
suppress lawless violence and the other
Yes.
crimes. But in the case of martial law, they are acting like ordinary peace officers. Aside from performing military function, they can perform the functions of ordinary peace officers.
Yes, Your
The
Honor.
PNP. So the authority of the AFP in martial law is much broader than what they can do in the calling out powers of the president.
Yeah, that's right, Your Honor.
Now, I just want, I've seen that you have many annexes in your comment, consolidated comment. Are these all official documents on which we can rely on in
Yes, Your Honor.
deciding the case?
Those were provided to us by the DND and the AFP, Your Honor.
So, okay. So this formed the basis for the decision of the president to declare martial law?
Among others, Your Honor, yes.
Okay. Thank you.
Thank you, Your Honor.
Justice Bersamin.
Thank you, Madam Chief Justice. Good afternoon, Mr. Solicitor General.
Good afternoon, sir.
Yesterday and a part of this morning, the petitioners have told us that the court had the duty, the mandatory duty. It's an overkill, but the duty to accept the proceeding initiated by any citizen in order to make this inquiry that we are making today. Is that the same position that you are, do you agree to that position?
Definitely not, Your Honor.
Why? What is your basis for disagreeing with the petitioners? That seems to be a very valid position.
Well, the Constitution says Supreme Court may review.
So only that word may is the basis of your position?
Not only that, Your Honor. If we adopt the literal meaning, any citizen, Your Honor, what if there are pranksters, there are people who are just out to derail the flow of justice, Your Honor? They can bombard this court with so many petitions.
So the word may refer only to the person or the one who brings.
Yes, Your Honor. No, I'm referring to the discretion of the Supreme Court. It may or it may not review.
Okay, supposing we have a petition, let's assume a situation that we have a petition. Do we have a choice,
Yes,
the
Your Honor.
Supreme Court,
Yes, Your Honor.
not to proceed on that petition?
Yes, Your Honor. If the petition is not filed in an appropriate proceeding, that's one. And based on your assessment of the petition, actually there is sufficiency of the factual basis of the proclamation. So you deny due course.
All right. Another point that the petitioners, I think it was Attorney Marlon, who made it very strongly that this need not be an existing procedure under the rules. This is a unique sui generis, that's also the term of the Chief Justice, to describe the appropriate proceeding that Section 18, Article 7 stated as the proper procedure to challenge or to review the determination by the President. Do you agree that this is not a Rule 65 proceeding that the Constitution refers to?
My position there, Your Honor, this is a certiorari proceeding under Article 8, Section 1 or Section 5, Your Honor.
That's your argument in your consolidated comment. I think you made a very extensive point there about arbitrariness being your standard of review,
Yes, Your Honor.
and necessarily standard of review based on arbitrariness has to come under Rule 65. That's your position?
Well, usually that's the function of certiorari, Your Honor.
Okay.
Grave abuse of discretion.
Now, do you know, would you not accept the position of Attorney Manuel, ba? Manuel, that this is a sui generis proceeding that the Constitution has referred to in Section 18, meaning
One of
no
its kind.
boundaries, it's an open
But
field?
no, sir, because, Your Honor, it's already there in Section, Article 8, Section 1 or
Yeah,
Section 5.
But it does not say certiorari, it does not say arbitrariness, it just says appropriate proceeding.
Article 8, Section 18, Your Honor, provides that the Supreme Court may review, etc. This jurisdiction should be read in conjunction with the petitions through which the Supreme Court exercises its original jurisdiction under Article 8, Section 5. And one of them is certiorari, Your Honor.
Yes, I admit that, but the point that is being made strongly by the petitioners, particularly their counsel, Attorney Manuel, is appealing to us, to me at least, because this is a unique kind of review. It's not the usual kind of review that we are being asked to do when it comes to the declaration of martial law or the suspension of the privilege of the writ of habeas corpus. Nowhere else do you have that kind of review. No other
The
proceeding.
expanded certiorari power of the court, Your Honor, under
They do not
Article
think so. So you insist that it would come under the second paragraph of Section 1 of Article 8?
That's the only remedy in the Constitution, Your Honor. So I do not agree with their position that they are at a loss. They don't know what remedy they're using. And they just invoke sui generis as
Well, here
a way
we have-
out, Your Honor.
Yes, this provision, Section 18, obviously defines a standard, sufficiency of factual basis and existence of a need to protect the public safety.
Yes, Your Honor.
Is that the same as Rule 65 review of arbitrariness?
Well, if there are sufficient facts, Your Honor, in other words, it is not bereft of facts, and the President reasonably believed that at the circumstances at the time he made the decision is that there is actual rebellion, then he is within his constitutional power to impose martial law, Your Honor.
Okay, may I ask that the government takes a position on this officially in the memorandum that you
Yes,
will
sir.
probably be made to submit, if you will be made to submit, because this will be enlightening to the court in future cases.
Yes,
All right. The
yes, we
next
will, Your
point
Honor.
that I'm going to is, are you saying here that the decision or determination of the President is inscrutable? Despite this provision that we are empowered to review sufficiency?
Well, the Constitution says, Your Honor, the Supreme Court may. So you have the discretion whether
So
or
it's not inscrutable
Yes, Your Honor.
because the President is not infallible
Yes, Your Honor.
and because the President is not final, unlike the Supreme Court.
Yes, Your Honor.
Okay, so you do now surrender to the thinking that we do have the means to review the determination by the President of his declaration of martial law.
Under the standard, Your Honor, of Section 18.
Yes.
Yes, Your Honor.
Yes. Now you were using the term judgment call. If it is a judgment call in ordinary parlance, that was a judgment that was made under the best of circumstances at the time it was made
Yes, Your Honor.
by someone who had to make a choice.
Correct, Your Honor.
And according to you, the President made that choice in the form of a judgment call.
Yes, Your Honor.
Okay? Now, I will assume that when he made the judgment call in Russia, he had available to him lots of information.
Correct, Your Honor.
Now, who do you think was with him when he made this decision, the determination?
I have no personal knowledge, Your Honor, because I was not with him in Russia, Your Honor.
Was the executive secretary there?
I think so, yes, Your Honor. was
Secretary Lorenzana was not there
I'm not quite sure about that, Your Honor.
because the proclamation was datelined Russia.
It was signed in Russia,
In
Your Honor.
Russia. Sean Connery was there? Okay, I was just...
From Russia with love. Yes, Your Honor.
All right. My concern here, Mr. Solicitor General, and I think you should contribute to this matter later on, is that this is probably the first occasion that the court would be so inquisitive about the nature and kind of proceeding that we should use for purposes of reviewing. Reviewing, that's the term the Constitution uses.
Yes, Your Honor.
Reviewing the determination of a sitting president of the factual basis for the sufficiency of the factual basis for his declaration. I have no further questions, Chief. Thank you.
Thank you, Your
Thank you,
Honor.
Mr. Solicitor General.
Cleonen.
Good afternoon, Mr. Solicitor General.
Good afternoon, Your Honor.
With your apologies, I would like to declare that I sometimes follow your statements. And indeed, I am very happy that during the anniversary of the Solicitor General's office, you mentioned that you were going to respect the decisions of this court.
Of
Am I
course,
not
Your
correct?
Honor.
Yes. And that you are not going to tear any decision that we are going to issue.
Because your decision might be very thick, I will be
Yes.
unable to tear it anyway if I like to, Your Honor.
Very good, Solicitor General. Our minds travel along the same wavelength.
Yes, Your Honor.
So you are, but I was disturbed earlier, prior to your anniversary, that in a press conference in Malacanang, you did mention in response to a query of a reporter in the Malacanang, with the Malacanang Press Corps, that you said that there is a possibility of suspending the Constitution. So are you now changing your mind that there is no possibility ever of suspending the
I
Constitution?
cannot recall that, Your Honor.
Okay, maybe it was my recollection that is bad, but I do remember having watched it on television. Also, that there was a statement that you made, which I think now you clarify with Justice Bersamin, that when there is a conflict between Congress and the Supreme Court, that the President can be the arbiter, the final arbiter. Do you still maintain that position?
I did not say that, Your Honor. I don't remember saying that.
Okay, thank you. It seems that my impression of what I saw might have been really different. So I go to our next point. To understand the context of the facts that you have presented, it is important that we look at the entirety, the global picture, and the context of what is happening in Mindanao. Because I think you will agree with me that we cannot see Mindanao from the lens of Manila. Is that not correct?
That's correct, Your Honor. That's why I'm inviting the petitioners and their counsel that we go to Marawi to see what's happening on the ground.
Counsel, the truth is that the week that it was declared, I did attempt to go to Marawi, except that I did not get the proper clearances. And probably you and I can go at some point, but not now. But the point there is that we do have to see it not from the lens of Metro Manila, but from the lens of Mindanao, the culture in Mindanao, and the religion that we are dealing with. Is that not correct?
Yes, I know for a
Yes.
fact, Your Honor, that you, before you were appointed here, you were very busy there going to Mindanao because of the
Yes.
peace talks, Your Honor.
In fact, one of the characteristics of this administration is its commitment to see the Philippines not only from the lens of Luzon, but also from the lens of the different peoples and cultures of Mindanao. Am I not correct?
You are correct, Your Honor.
Yes. So let me start, and I hope you bear with me because it has some relation to what you have shown us a while ago. So I am now showing you this symbol. Okay, and for the record, I am doing a fist bump.
Duterte punch, Your Honor.
Duterte punch, okay. So this is the Duterte punch, correct?
Yes, Your Honor.
Yes. Is there a national registry for the Duterte punch? In other words,
I don't think so, Your Honor. That
Yes.
was a campaign slogan.
it was a campaign slogan.
Yes, Your Honor.
And therefore, just because you can do that particular symbol, the Duterte punch, does not mean that you are, let us say, part of the campaign of Duterte. Is that not correct?
Well,
Because
maybe,
today I see a lot of other individuals who were not part of your campaign, I was sure, that are now seen doing the Duterte punch.
maybe they were not part of the campaign, but they voted for him or
Yes.
supported him, Your Honor.
But is it possible to do this punch and hope to be affiliated with the ideas of the president?
Well, that is a visible sign that you are for Duterte.
Yes, and
Your Honor.
therefore, that it is not necessary that you were part of that campaign of Duterte, except that now you are a believer of what he
Yes.
stands for.
Now you have seen the light, Your Honor.
Yes. Is it also possible to do this punch, but at the same time actually simply be a pretender?
Well, that
Meaning
is
to
possible,
say,
Your Honor.
Just to get, let us say, maybe get away with a traffic violation, although it's not possible that you would
Well,
probably do it.
That will be a dangerous sign, Your Honor, because the arresting officer might think you are belligerent.
Yes, but it can be possible that that symbol is used by someone, although not really part of the campaign of Duterte.
Yes, Your Honor.
Although not really a believer, but simply because they are pretending to be for their own reasons. Is that not correct?
Well, I'm reminded of that song, The Great Pretender, Your Honor. There are many pretenders in this country, Your Honor.
Yes, and probably when we go to Marawi, we can sing it together
Why
in
not,
a
Your Honor?
video. Okay, okay. Now, let's go to the flag that you presented. There is an inscription there at the top. Can you read the inscription? It's in Arabic, I understand.
I'm sorry, Your Honor. Actually, I asked a Muslim friend to read to me.
I can read it.
Translate.
I
But
can read
he
it.
cannot read Arabic, Your Honor. So-
Yes, I cannot read Arabic, but I know what it means. It is the Shahada. The one on top is the Shahada, and in Arabic it is, if I pronounce it correctly, and I must say before I say this, that I am saying it for information only because it is a sacred phrase. La ilaha illa Allah Muhammadun Rusulu ilah. What it says is that there is no God but Allah, and that Muhammad is its prophet. That is the Shahada.
Thank you for that interpretation, Your Honor.
And every believer of Islam knows the Shahada, they pronounce it, and it is a creed of belief. It is like, if I may do an analogy, of course, which is very crude, it is in the Catholic faith, the Apostles' Creed. Would you agree with me?
Of course, Your
Yes.
Honor. I don't know any Arabic, so
Yes.
I have to agree
But you
with
can
you.
check it with your sources.
Yes,
There is
Your
there
Honor.
a symbol below. It is it's a circle, but not so much of a circle. It is actually saying Muhammad is the prophet. Muhammad is the prophet, and it is the seal apparently attributed to the Prophet Muhammad that is used to seal letters and many other official documents before. So I think that is what the flag means. And looking at it simply, it is quite generic. Except that, of course, it has a meaning because others have given it meaning. Am I not correct? That flag, of course, is flown by ISIS.
Yes,
Is that
Your
not
Honor.
correct?
Yes, Your Honor.
Do you know that it is also the flag of other groups other than ISIS?
I'm not aware of that, Your Honor.
Al-Shabaab of Somalia uses the same flag.
Okay.
AQAP, an Al-Qaeda-affiliated group in Yemen, also use the same flag. Many others actually use it but pretend that they are part of either ISIS, Al-Shabaab, or AQAP. In other words, Mr. Solicitor General, just because somebody has that flag, which contains the generic creed of someone that is Islam, a believer, someone who submits to the will of Allah, and that it is in their possession, would you agree with me that it is not necessarily the only fact that will prove that they are part of ISIS?
Well, in the case of Isnilon Hapilon, Your Honor, we have attached in our
We can go to that later.
comment
But
that
I
he
can
was,
go to.
he
We
was
can go
even,
to Hapilon later, but just the flag itself, in order that we can take the flag, that fact in context, so
Well,
that we can determine the sufficiency of the facts that are being used now to declare martial law.
Your
Just possession of the flag in itself, does that necessarily mean that one is actually a member of ISIS, or it can be possible that one is simply pretending to be ISIS?
Your Honor, this ISIS flag was recovered by the Scout Rangers on May 23 in Barangay Basak, Malulot, Marawi City, when they had an encounter with the Maute group and the group of Isnilon Hapilon, Your Honor. So this was actually,
I understand. And
in the context of that, they are members of the ISIS, Your Honor.
I understand, okay, with your statement. First, I do not denigrate. In fact, I salute the ability of our Scout Rangers to go through hellfire in order to be able to defeat a violent group. And of course, I acknowledge that it was found in Marawi. It was found in a barangay in Marawi. I acknowledge that. But is it not possible that the Maute group is simply a criminal gang wanting to project its own power with all the pretensions of the ISIS, and by that symbolism, scare everybody else and project a power which is not actually theirs?
As far as I know, Your Honor, and based on the literature and briefings that I've received, the Maute group is now ISIS-linked, Your Honor, because Hapilon now is the emir of the Philippines.
We will go to that literature
Yes, Your
later,
Honor.
and we will distinguish an emir from a wali and
Yes, Your Honor.
the nature of the learnings of Hapilon later on, because I think that is important in order to put the facts in context. Now, in Mindanao, there is this popular term, pintakasi. Pintakasi. Are you familiar with this term?
Cockfighting, Your Honor.
As used in armed conflicts in Mindanao, and as used by the army, there is this word called pintakasi. In fact, it was memorialized in a recent movie, The Sun Behind My Head, Ang Araw sa Likod Ko, which was an indie film which was shown in some of our theaters. Would you know the meaning of, do you have an AFP consultant with you now?
No, Your Honor.
Would you know the meaning of pintakasi?
Can you-
Pintakasi is a term used by the military, which is, in fact, the reason why they do not do surgical strikes in communities. Because whenever they attack a particular community, which was what happened in Albarca, which was in fact what happened also in Mamasapano, that if you do not have substantial force, what happens is that clan members, family members possessing a gun and ammunition will come out in your support just because there is an alien or a foreigner or an armed force that is with the government that is attacking a particular group. As a matter of fact, Mr. Solicitor General, the word was used in one of the petitions. Okay, so that is pintakasi. Meaning to say that the attack did not come from the rebels or the armed groups or the violent clans. But the attack first was initiated by government, and because they disrupted a particular plan, then suddenly all other sympathizers would come out and support in order to defend or relieve the pressure on a particular group. That is pintakasi. Would you say that it is possible that what happened and what is happening in Marawi is simply pintakasi and not really the ISIS wanting to plant its flag in Marawi? Do you think that is possible?
Well, in the realm of possibility, that may be possible, but I do not believe that was the case in Marawi, Your Honor.
In fact, prior to what happened in Marawi and prior to the pronouncements of the President, is it not true that the Department of National Defense, through its secretary, the Armed Forces of the Philippines, through its spokespersons, were hesitant to link the Maute group to the ISIS in consideration of the fact that the Maute group might have just been a violent clan doing criminal activities, wanting to project themselves so that they can have more resources coming from maybe foreigners or coming from those that are more ideologically oriented.
I'm sorry, Your Honor, I cannot agree to that, Your Honor.
Yes, but that's one way to look at the facts, correct? And what we have to do is look at the details that you have put in your petition and perhaps see whether that can be a reasonable way to interpret what is happening there rather than to say it is rebellion immediately. I think that is what the petitioners are saying in terms of what is the culpable intent that they actually did. But let's not just rely on that. Perhaps we can ask ourselves, what is this ISIS? And is it really possible that there be a caliphate in southern Philippines?
Yes, yes, Your Honor, there can
and
be a possibility.
Would you have experts to back you up? Statements of experts in security studies where they have said that there can be a caliphate in southern Philippines, or is the weight of experts the reverse? This, I'm talking about several journals that have come out on security studies stating that it may not be possible to establish a caliphate, let alone a wilaya, in southern Philippines with the group that alleges to be the conduit to the ISIS in Syria and in the Levant.
My personal view of that is we take seriously this threat, Your Honor.
I understand your personal view and I have a great deal of respect for it. But in terms of the security studies literature, which informs our intelligence community, would it be possible that there is a statement that there can be no wilaya or caliphate in the Philippines?
Well, Your Honor, we, in our Annex 1, this is the BIC, Your Honor. This will answer for itself, Your Honor. There is a possibility, and in fact, had they succeeded in capturing Marawi, Your Honor, this ISIS-linked rebels led by Isnilon Hapilon would make Marawi as the seat of their power, Your Honor. Because their grand plan is to establish a caliphate in Mindanao,
Can you submit
Your Honor.
I think I've seen Annex A. But on the other hand, there is this person whose name is Joseph Franco of RSIS, who have done studies of these extremist groups for a long time. And, well, he has published in the East Asia Forum that Mindanao is really no place for a caliphate under ISIS because of the ideological disharmony between the groups that are claiming to be wanting to be part of it and the ISIS in general. But let us examine it. Okay. There is a difference, there are many differences between Christianity and Islam, and I think it is important to understand how people affiliate within different sects in Islam as differentiated from Christianity. For one, for example, Christianity believes that Christ was a God. Is that not correct? Am I not correct?
Christianity believes that Jesus Christ is Lord.
Jesus is a Christ.
Yeah, God, Your Honor, yes.
That's Christianity. And that therefore, within the rubric of Christianity, there are many different sects. But all of them believe that Jesus is Christ. For example, there are the Roman Catholic, there are the Orthodox that believe in it, there are the Methodists, the Baptists, etc. Would you agree with me?
Yes, Your Honor.
And there are people who believe in a very conservative interpretation of the Bible and the works of Christ. Is that not correct?
Yes, Your Honor.
And in the history of terrorism in this planet, that there were, in fact, groups that believed in the existence of Jesus as Christ that resorted to violent means. Is that not correct?
You're referring to what group, Your Honor?
The whole planet, the whole history of this world. That there have been instances where there were groups that believed in Christianity yet did terroristic acts.
I'm not aware of it, Your Honor.
IRA,
IRA,
and
okay.
many others, correct?
Yes.
Okay, now, in terms of Catholicism as a religion, it is easy to know who are affiliated with it because there is one Pope. There is one Catholic Church, correct? And that there is one Pope, and to be baptized, you have to be baptized by a priest that has a genealogy towards that Pope. Is that not correct? So there is a central figure in Catholicism, correct?
And that central figure is
The Pope.
the Pope.
Yes.
Okay.
He is the vicar of Christ on earth. Is that not correct? I
I
hope
may
am
not agree with the theology, but if that is
Yes.
the Catholic tradition, yes.
the
Your Honor.
institution, yes. I may share with you your disagreement with the theology, but I'm just looking at the facts in terms of Christianity. For Islam, is there a Pope in Islam?
Well, they
Mr.
are
Solicitor General,
monotheist, Your Honor,
I thought we
monotheist.
said that we needed to understand the facts from the lens not of our people in Manila, which is of course dominated by Catholic individuals like me, but we needed to interpret it from the point of view of that culture so that we make a correct call. Therefore, I am asking you this, because Marawi is not, as you said, it is the center of Muslim faith.
Yes, Your Honor.
Yes, which of course I will ask you later because I do not agree that it is how all ethno-linguistic groups in Mindanao actually see it. But the point is that you say that it is predominantly Muslim. So we have to understand how the Maute group actually sees their role and what it is taking advantage of in terms of their faith. Because ISIS is a political or perhaps a secular organization manifesting a belief within their faith. Okay, so we need to understand this, and we cannot understand it only from the lens of Catholicism. And therefore, for Islam, is there a Pope? There is none. And in fact, it is one decentralized religion, and that there are many schools of thought that predominate over Islam, correct?
Just like Christians, Your Honor.
No, for Christians, there is always a bishop, there is always somebody in charge, like in even for the Anglican Church, etc. But for Islam, there can be many different groups. As a matter of fact, there is Sunni and Shiite, correct?
Yes, Your Honor.
And we can say that ISIS, immediately from that flag, is Sunni, because Shiite has 3 portions in the Shahada. Sunni has only 2. And therefore, this flag is Sunni. Now, Marawi, is it Sunni-dominated or Shia-dominated?
I don't know, Your Honor.
But isn't that important to know in order to be able to appreciate whether these people that fly this flag are not pretenders, that they are indeed part of that faith? Well, mostly Sunni. But there are, of course, several missionaries that are Shia already located in Marawi prior to this incident. But on the other hand, it is not simply Sunnism, because the Sunni are divided also into different points of view. And among one of the more important is Al-Salaf Al-Sali, or Salafi, which believes in the piousness of its forefathers. They want to go back to the very beginning. Salafi, there are 2 types. There is the Salafi, of the first types of Salafi, which want to see religion only as a reference, but separation of church and state. And on the other hand, there is Salafi that is jihadist and extremist and can be violent. And that is the brand of Al-Qaeda and ISIS. Am I not correct?
How can I disagree with you, Your Honor? You're a Muslim scholar.
No, I'm not a Muslim scholar. I'm just reading background material in order to be able to see the facts from the lens of people that are there, rather than from on top, from Imperial Manila, because this is not the theme of the administration. It has to understand the facts from their point of view. Therefore, Maute started out as what kind of group? Did they immediately start out as ulama or alim? Omar Maute and his brother, are they ulama or alim?
Can you supply the answer, Your Honor?
I'm asking you because
Because
in
I can't-
order to be able in order to be able to assess the sufficiency of the facts, in my view, from my own perspective, I need to understand whether they are truly the real fist bumpers or simply the pretenders. Because if they are pretenders, then we're doing them a big disfavor. We're doing them a favor. We are actually building them up and giving them the terroristic label that they do not have. in any case. Therefore, perhaps you can cover that in your memoranda. But let me just look at Hapilon. Is Hapilon an alim or an ulama?
I don't know, Your Honor.
He's not. Does he speak Arabic? Was he a speaker of Arabic fluently when he was recognized as emir?
I have no personal knowledge of that, Your
The
Honor.
answer is the literature says no. He was not even a fluent speaker in Arabic. And Hapilon was a breakaway from the Abu Sayyaf group in Sulu. He stayed in Sulu for a long time. He is Yakan, but he went back. But the Abu Sayyaf in Sulu, is this the ISIS ASG that we are referring to now? There are
It is
two ASGs. One
The
is in...
ASGs of Isnilon Hapilon, Your Honor.
Yes.
are
There is the
ISIS.
ASG in Basilan. This is Hapilon. There is the ASG in Sulu. This is Sahiron, if I'm not mistaken. The one in Sulu is more active in terms of kidnapping. They're a criminal syndicate from my point of view. Of course, using Abu Sayyaf and tracing their genealogy from the Jalani brothers, who were more theological and ideological at the very beginning. Hapilon moved to Basilan and then recreated the ASG, which is now affiliating itself or trying to affiliate itself with the ISIS group. So when Hapilon went to Marawi, are we therefore that certain that this group is actually the ISIS that we are talking about? Or is it possible that these are only wannabes? These are only clannish groups. And you said 40 in ASG Basilan, 260 plus among the Maute. These are wannabes. They want to project a power of strength, and what they can figure out, it's like a kidnap for ransom gang calling themselves the Martillo gang in order to be more scarier. And therefore, they are now saying that they are ISIS. Is this not a possibility? Or are we taking hook, line, and sinker the propaganda that they did, which is to fly the flag and to actually say, I am the emir, and therefore projecting themselves as a matter of fact, as more powerful than they really are?
Based on the briefings we received from the AFP and DND, Your Honor, and the evidence that we submitted attached to our comment, I believe they are really ISIS.
There is a new brand of terrorism that we have today. And this is different from the Al-Qaeda type that we had before. In fact, Al-Qaeda discovered it as soon as they did the 9/11 bombings. It is the type where a single individual, a lone wolf, would be able to do a bombing. Of course, it may be not that difficult or not that easy either. It may require a lot of preparation, and then put it in social media and project itself. That is the new type of terrorism we have today. And innocent members of social media usually assist by reposting or liking or retweeting this particular activity. Is this not what is happening to a group of 200 individuals that is found in Marawi? True, they are engaged in hostilities, but these hostilities are very real. People are getting killed. But to actually label them as ISIS might not be that accurate.
Well, I still believe in the sources of our briefings, Your Honor.
Okay. That's why I look forward to tomorrow when the intelligence officers of the DND and the AFP would be available for the court to examine the basis of the facts that have been presented. In fact, I am very curious as to the operational directive that the Chief of Staff may have to all the unified commands. Okay, let me move to another point. But my point there was, perhaps we should see the facts in the context of the culture in Mindanao. By the way, apart from religion, Mindanao is also divided into ethno-linguistic groups. So the Maguindanao is different from Maranao. Would you agree with me?
Yes, Your Honor.
The Yakan and the Tausug are different from the Maranao and the Maguindanao. Would you agree with me?
Yes, Your Honor.
And the
because
Sama is different from the Tausug. Sama is found in Tawi-Tawi, Yakans are found in Basilan, Tausug in Sulu, Maguindanao in Cotabato area, and the Maranao is the areas where we are involved right now. Do you agree with me with that?
Yes, Your Honor.
Yes, and-
in fact, our president has Maranao blood, Your Honor, running in his veins.
That's very nice to know that the president is really from the area. Okay, but in any case, I move on to another point. In 2016, Proclamation 55 was promulgated. Proclamation 55 declared a state of national emergency and called out the armed forces. In 2016, would you know who was declared to be responsible for the Davao bombings? In fact, it is in the...
Can I refer to our
Yes.
comments, Your Honor?
It is actually in the report of the President to the Congress.
According to the report, Your Honor, it's ASG,
ASG,
Abu Sayyaf Group.
Abu Sayyaf Group, Sulu or Basilan? Isn't it not the one now affiliated with the Maute?
I think so, Your Honor.
Yes. Now, because it's in the report of the President to Congress. Now, in other words, the armed forces was already out. Intelligence officers of the ISAP was already operating, and therefore they were guarding all parts of Mindanao. Is that not correct?
Yes, Your Honor.
Yes. The President went to Russia, and with the President was the Executive Secretary, correct?
I think so, Your
Yes.
Honor.
And with the President was the Chief of Staff, General Anyo. Is that not correct?
General Anyo. Well, I'm not quite sure about General Anyo being there, Your Honor.
He was with the President in Russia.
Okay.
And then the service commanders of the Army and the Navy was with the President also in Russia. Is that not correct?
I don't think so, Your Honor.
I think they,
Based on these notes, it's Secretary Lorenzana, PNP Chief De La Rosa, Secretary Esperon, Secretary Aguirre,
Army Chief,
and Secretary
Flag
Abella.
Officer of the Navy.
The name of the Chief of Staff is not here, Your Honor.
Okay, in any case, the President was in Russia. And while in Russia, meaning to say he left Mindanao, particularly may be confident that everything was going to be all right. Before the declaration of martial law, operations were given a go signal. In order to serve a warrant, this was not under exigent circumstances, there was a warrant for Hapilon. To serve a warrant in Marawi, correct? Before martial law,
Yes, Your Honor.
while the President was in Russia. So the interpretation was everything was all right in Marawi. Is that not correct?
Probably, Your Honor.
And that was under the condition that Proclamation 55 was in place. The military could go anywhere in Mindanao, in fact, in the Philippines, because the state of emergency was still there, correct?
Well, there was a composite
Yes.
team, Your Honor.
So what happened in Marawi can
the-
be a failure of intelligence.
Well, perhaps the entire picture was not yet clear, but they were already just like a jigsaw
Who is
puzzle, Your Honor.
Brigadier General Nixon Fortes?
I don't know him personally, Your Honor.
He is the commanding general of the 103rd Brigade, and he was recently replaced. During these armed hostilities, 103rd Brigade is Marawi, and the commanding officer was removed, promoted to Assistant Division Commander, and replaced by his Deputy Colonel Generoso Ponyo. Don't you think that that is an indication that there was a failure in terms of protecting Marawi before the actual operations that was done?
I cannot surmise, Your Honor, on the real reason, but
Could
the
it
fact
not
is-
be possible that we are now declaring martial law because of a failure to actually pursue Proclamation 55, which is calling out the armed forces. The armed forces is composed of so many branch of service. I respect its officers. I know their caliber. I know the caliber of ISAP. And of course, a lot depends also on area commands and on brigades that are on the ground. Therefore, isn't this martial law now a projection or, well, maybe we should look at what really happened, what was the mistake, rather than putting this entire country under this kind of a exigent situation of declaring martial law. Okay, no answer, but nonetheless.
Well, my answer, Your Honor, is that was the presidential prerogative, Your Honor, based on the Constitution.
Could the president have misinterpreted the situation?
Well, as long as he reasonably believed that there was an actual rebellion, Your Honor.
So there was Proclamation 55, the military was out, there was a brigade commander, an entire brigade in charge of Marawi. I know the former brigade commanders of the 103rd, they were very familiar with the area. General Pangilinan, who later on became the 6th Infantry Division commander, I think was brigade commander at the time that I was negotiator. They knew the dynamics of Marawi, yet they failed to actually see that there were these sleeper cells, if they were sleeper cells of ISIS that came in. And government forces were overwhelmed, and our initial reaction is therefore to declare martial law. Could that be a possible scenario?
As far as I'm concerned, Your Honor, the President exercised his constitutional power.
Okay. So martial law now is throughout the entire of Mindanao because of the reasons that you have stated. How many weeks has the operations been ongoing in Marawi?
I think we are now on the 3rd week.
Has there been a sympathy strike of the AKP in Palembang?
I'm not aware, Your Honor. I do not know. There might be, but I don't know.
Because in terms of the fighting in Mindanao, it is always that when a group is under siege, that sympathy groups or allied groups are going to do their best in order to try to relieve the siege. That's the history of military operations in Mindanao. Am I not correct?
And in fact, Your Honor, I think the BIFF, which is part of the 4 terrorist rebel groups, there was a skirmish with the military, Your Honor.
While the operations were ongoing in Marawi?
Yes, Your Honor.
What about the Abu Sayyaf in Basilan?
Well, their leader was in Marawi, so
What about the Abu Sayyaf in Sulu?
I have no information to that effect, Your Honor.
And probably you can submit to us the other sympathy strikes that have happened alongside this, because your justification of martial law is that it can spread to the other areas. By the way, where is Hapilon now?
He's believed to be holed up in Marawi City, Your Honor.
Yes. And would you know the actual situation now?
No, Your Honor.
Is it possible that by the time we decide this case, Marawi would have already been put under control? The entire of Marawi, including that barangay, which is now where the armed personalities are holed up.
That is our hope, Your Honor, and I devoutly wish for that, Your Honor.
And would it be possible then that martial law will be lifted as a result of that?
Well, that is the... It lasts only for 60 days, Your Honor. So,
For 60 days.
yes.
Soljan, what happens if in 60 days, all the lawless violence in Mindanao is not quelled?
Again, it will be the President's responsibility
Because
to
60 days,
exercise
you would
what
agree
power
with
he
me.
will use, Your Honor.
You would agree with me that 60 days, it is impossible to deal with all the armed conflicts in Mindanao.
Yes, Your Honor.
Yes. And therefore, that it is the actual reason for declaring martial law might not be a reality.
Well, I'm an optimist, Your Honor. So
I know the
hope-
president to be a very pragmatic individual, more pragmatic than many of the former presidents. He is a man of action,
Correct, Your Honor.
and he will do only the things that he can do. That's what he said.
Yes.
I remember very distinctly when you were with him campaigning. And I am sure that he is aware that he will only declare 60 days martial law and set an objective that is enough in order to accomplish it. Am I not correct?
Yes, Your Honor.
So it cannot be that it is to quell all lawless violence. Is that not correct?
Beg your pardon, Your Honor.
It cannot be that the 60-day period of martial law is to order the armed forces, West Mincom and Eastern Mindanao Command, to actually fix all the armed conflicts in Mindanao?
Well,
Because
The-
if we do that, the field officers will be very confused. Because then they will not know whether to focus their attention simply on the Marawi siege or to actually go for the NPA in the Caraga region, the AKP in Palembang, the Abu Sayyaf in Sulu, and so on and so forth.
again, Your Honor, this will be the President's call, Your Honor.
Okay. Anyway, I go to another point. There is arrest order number 1. Would you have a copy of arrest order number 1?
Saan ito? Arrest order number 1. Yeah.
Can you turn to page 3 of arrest order number 1? So arrest order number 1 contains the persons of interest that are about to be arrested or ordered to be arrested by the Secretary of National Defense. Can you look at the fourth name from the top on page 3?
Page 3, Your Honor.
Yes, page 3 of arrest order number 1, the fourth name from the top. There is an order to arrest.
Alias Boy?
Yes.
Yes, Your Honor.
So there is an order from the DND to arrest wherever found in the Philippines a person by the name of Boy. Am I not correct?
Well, maybe it refers to
Yes. Is there any other?
Amano Romato alias, and he has many aliases, and there are many
I think
aliases.
these are different individuals. Am I not correct?
I'm not sure, Your Honor. It
Yes,
could
but
be,
there is-
it could refer to the same person using many aliases.
Yes, this is alias Boy. Down the list, there is also an alias Baby.
Alias, where, Your Honor?
1, 2, 3, 4, 5, 6, 7, 8, 9 from the bottom. There is an alias Baby. So any
Baby.
person whose name is Baby can be the subject of this arrest warrant.
But above it, Your Honor, there's a name, Muhammad Noam Maute, with different aliases.
Yes, but it can
So-
refer also to alias Baby. Am I not correct?
It could be one of the aliases of a certain person named here, Your Honor.
Yes, and of course there is also there, somewhere in the list, a person by the name of alias Bobby.
Alias
Bobby?
Bobby.
Yes.
Under the name Joselito what's this? Muhammad Nuaim Maute.
Okay, so therefore in this particular list, you have all of these names, and this is an arrest order. Let's go to General Order number 1. I'm sorry, before we go to General Order number 1, you have submitted Department of Justice, Department Order 385. 385. And this was during the period of martial law, June 7, 2017.
Actually, Your Honor, I was wondering why we were ordered to submit this Department Order 385, which has nothing to do with the Marawi incident, Your Honor.
Oh, wasn't it issued by the DOJ after the photograph was shown to the media? And it now says the alleged destabilization plot against the government by some senators, very broad, and other opposition leaders.
This has nothing to do with the rebellion that we are litigating now, Your Honor.
The destabilization plot here is different. So this is
Well-
not under the cover of martial law.
No, Your Honor.
So it's even worse because it was issued without martial law.
Maybe you should ask the Secretary of Justice, Your Honor.
But are you not affiliated with the DOJ?
Under the law, Your Honor, we are autonomous and independent from the DOJ.
Okay. Good to know that this is not part of the martial law, but still it is troubling because it is now doing the same thing as martial law in 1972, where there were portions of the administration at that time that actually went after opposition senators by the name of Jose W. Jokno, Tanyada, Sagisag, and many others.
Well, this Department Order of the DOJ is irrelevant in this
At
proceedings,
least
Your
I
Honor.
am a bit relieved that it says senator, so therefore Lagman is not part of this.
Unless
I'm
they
sorry,
are...
opposition leader. So he might be part of this. But in any case, at least I am clarified with that. Now, we have...
I hope, Your Honor, they are not part of the conspiracy of rebellion. I'm just kidding, Your Honor.
Yeah, okay. I am a bit concerned by that statement, but in any case, I'll let it go. We have General Order Number 1,
Yes, Your Honor.
and I think you know what I pointed out this morning. And in General Order Number 1, there is the authority to do warrantless arrest for all lawless violence. And this comes direct from the Office of the President. Further, the AFP and other law enforcement agencies are hereby ordered to immediately arrest or cause the arrest in the above-mentioned acts. And the above-mentioned acts includes all acts of rebellion and lawless violence. Can you assist us interpret this martial law order?
We will discuss this in our memorandum, Your Honor.
Okay? In other words, do you agree with me that it covers arrest for any kind of lawless violence?
No, it refers to rebellion, Your Honor.
It says rebellion and lawless violence.
Well, it's the... basically, it is the rebellion, Your Honor, that may also include lawless violence
In other words...
by the rebels.
Yes. In other words, perhaps an implementing regulation can probably clarify that to us.
Yes, Your Honor.
Yes. In fact, are you familiar with the military term OPORD? O-P-O-R-D. OPORD. Or
Okay.
in English, it is Operational Directive. This is usually a commanding officer stating his intent to his troops in writing as to the scope of the mission and the coverage of that particular mission and the maneuver, the deployment of the troops, etc. Would you know if there is an operational directive from the Chief of Staff of the Armed Forces of the Philippines to the unified commands of the Western Mindanao Command and the Eastern Mindanao Command, as well as the service units in relation to martial law?
I have no personal knowledge, Your Honor. I don't
Yes.
know.
I know the military, they always need an OPORD in order to be able to operate, and you were required this morning to try to find out if that was available for our consumption and for our discussion tomorrow. Because that may help us clarify the scope of General Order Number 1. General Order is issued by the President as Commander-in-Chief, am I not correct?
Yes, Your Honor.
Yes, and the Commander-in-Chief, being the highest in the hierarchy of the military, will give an order to his subordinate. The subordinate gives an operational directive to his subordinates. The subordinates cascade the command of their hierarchy. And therefore, we wish that you provide us with a copy of the operational directive. Of course, I am very aware that there is some operational security involved, that you do not want to publicize publicly the actual maneuvers of the armed forces of the Philippines. And therefore, we would appreciate that it be with the proper cover. And I think I am seeing that cover of top
Yes.
secret.
Yes, Your Honor. We
Yes.
cannot divulge it, Your Honor.
Yes, so at least only to the court first, and the court will determine upon the manifestation, your manifestation this morning, as to whether that can be in session with the respondents or only kept to us in the briefing that will be done by the DND or the AFP.
What we ask from the Honorable Chief Justice is a briefing, Your Honor, not a public hearing, Your Honor.
Yes, I understand, because that is under, I see the red cover, and red always means, I think, secret or top secret, correct?
Yes, Your Honor.
Yes. Top secret is green, if I'm not mistaken. But in any case, it is red, and therefore, it is there. Of course, in an operational directive, there are portions which are, I think, harmless. Like, I think part 1 there is situation, part 2 is overall mission, part 3 is the execution. And execution under letter A covers the coverage of actually this section. But in any case, thank you that you are going to provide us with a copy of that. I go to another point. Are you familiar with Mr. Marwan?
Who, Your Honor?
Marwan. Zulkifli bin Ali Marwan. Are you familiar with him? He's dead. He was the object of the Mama Sapano.
Mama Sapano.
Yes. Would you
Your
know
Honor.
his nationality?
I don't know him personally, Your Honor.
He was Malaysian.
Okay.
Are you familiar with the name Mawia, who is also a person of interest in Mindanao for the longest time? He is Singaporean.
Can you introduce me to him, Your Honor?
Yes, he
I
is
don't know him.
Singaporean.
Okay.
Also a trainer in bomb making and
Okay.
linked with several groups such as Jemaah Islamiyah.
I
So,
don't
in
know
other
him,
words, for the longest time, there have been foreigners sojourning through Mindanao. And as a matter of fact, there have been Filipinos also arrested in Indonesia or Malaysia or even in Syria. Am I not correct? And therefore, this presence of foreigners is not really something that is totally new. And would you agree with me, therefore, that if martial law was not declared before, then there may not be sufficient reason to declare it now?
Well, as I said repeatedly, Your Honor, this is the presidential prerogative to declare martial law. So if he declared it on May 23, there must have been a reasonable belief that the requirements of the Constitution were present.
Okay. Now, maybe as a final point, you see, I really follow you. So this morning, there was an ambush interview of the Solicitor General in front of the building. And you mentioned about false news, if I'm not mistaken.
I was not interviewed, Your Honor, when I came here this
But
morning.
I saw it in Rappler this morning, so it's in YouTube also. You were responding to one of the comments made by the petitioners. Anyway,
It
it's about...
was here, Your Honor. I was
Oh,
here.
yeah.
I was
It's about-
seated here.
It was about false news.
Yeah,
Okay.
because he labeled me as an inventor, Your Honor.
Yes, okay.
I was inventing facts, and I didn't like it, Your Honor.
Yes, I know.
I thought he
understand.
was a friend. We were discussing
Yes.
yesterday. We were chatting,
Yes.
and then behind my back, he was backbiting me. He was telling that I was an inventor. I'm not an inventor of facts, Your Honor.
I understand. That may be the fog of war, Soljan. But in any case, that's why I am concerned about your distinction between arbitrariness and correctness. Because if you are not correct, then you are arbitrary. So isn't this distinction not real? Because as I follow you, you are very adamant in saying you cannot be false. If you are false, you are unreasonable. And therefore, there should be no distinction between correctness and arbitrariness.
Arbitrariness, Your Honor, is associated with the phrase grave abuse of discretion. So the President gravely abuses his discretion. It's not the factual accuracy of certain events.
So the President can act and declare martial law on a fact which is not true.
Sufficiency of factual basis. That is the standard in the Constitution.
In other words, Mr. Solicitor General, there is really no distinction between correctness and arbitrariness.
There is, Your Honor.
Okay.
Insofar as the standards of the Constitution are in issue, Your Honor.
I give you the last word for now. Thank you, Mr. Solicitor.
Thank you, Your Honor.
Justice Kagiwa.
Thank you, Chief. Mr.
Good
Solicitor.
afternoon,
Good
Justice.
afternoon. I know you must be very tired.
Well,
So
I'm
I'll
not
be
that
very,
young
very-
anymore, Your Honor.
Same here. I'll be very, very brief. In as much as this is actually a fact-gathering exercise as well, I'd like to do some fact checks, if you don't mind. Earlier, you mentioned that you castigated petitioners for relying on news accounts, which you said may not be true because it was part of government's SIWAR. Did I get you correctly?
Well, that could be the reason, Your Honor, just to boost the morale of the troops. That's part of SIWAR, you know, psychological warfare.
So much so that the implication was petitioners could not have relied on the news postings of statements coming from the AFP because they could have been part of SIWAR.
Well, that is a possibility, Your Honor.
All right. A lot of people are functioning on the news, and so I think very few items I just want clarified. In the PhilStar article, Colonel Edgar Arevalo, AFP Public Affairs, was quoted as saying the following, and I quote, "Pag pinapangalanan natin ang local terrorist group, pinapapogi natin sila, pinapasikat natin sila. Translated, when we call them ISIS, we are making them famous." And then Colonel Arevalo is quoted as further saying, "We don't have ISIS in the Philippines." I'd like to ask you if this is factually correct.
No, Your Honor.
So the statement of Colonel Arevalo here was not factually correct.
I don't know if he said that, Your Honor. I have no personal knowledge.
All right. So may I ask that you supply the court with an affidavit from Colonel Arevalo where he debunks this and denies that he said this? Okay?
Well, I will consult with his superiors first, Your Honor.
Of course. Okay. Just very few. Okay. A statement was made likewise by Public Affairs Office Chief Marine Colonel, again Edgar Arevalo, on May 23, 2017. And he says the situation in Marawi has stabilized. This is May 23, 2017. Security forces are in full control of the situation. The armed men we are dealing with are not ISIS, but members of local terrorist groups. And he made other statements. Again, to your knowledge, as a fact-finding exercise, would you know if these statements are false or true?
First of all, I don't know if he made such statement at all, Your Honor.
This is a statement by Public Affairs Colonel Arevalo as appearing in the AFP's website on May 24, 2017. This is the AFP's website. It's also posted on AFP's Facebook with a video, and it's dated at 11:14 p.m. of May 23, 2017.
Well, as I said, Your Honor, I have no personal knowledge of that. If that is posted in the,
Exactly my point. If it is
It's
posted in the
posted-
AFP website, can we assume that these statements are accurate?
I disagree with that, Your Honor, actually. It could
So-
be, as I said, Saiwar.
All right. So maybe again, with due deference to the superiors of Colonel Arevalo, can you supply the court with a statement, notarized statement, that this statement of Arevalo posted on the AFP website is in fact not accurate and was, because it was dated May 24, just part of Saiwar?
I will ask his superiors, Your Honor.
Thank you. That's all.
Thank you, Your Honor.
Justice Carpio.
President declares martial law. Is he exercising an executive function, a judicial function, or a quasi-judicial function?
Under the Constitution, Your Honor, he's exercising it as the President, the executive.
The President is the executive.
Yes, Your
so
Honor.
he's performing an executive function.
Yes, Your Honor.
And it's a discretionary function, of course, because
Yes, Your
he
Honor.
may or may not
Yes, Your
declare
Honor.
martial law. Now, under Rule 65 on certiorari, the officer who is the respondent is exercising judicial or quasi-judicial function, correct?
Yes, Your Honor.
So it cannot fall under Rule 65.
But it may fall, Your Honor, under Article 8, Section 1.
Article 8, Section 1, what's that?
Judicial power includes the duty of the courts of justice to settle actual
That's in the
controversies.
Constitution.
Yes,
But-
Your Honor, in the
But you
Constitution.
agree with me that it cannot fall under Rule 65.
Because of that phrase, Your Honor, quasi-judicial. Yes, Your Honor.
So it has to fall under the Constitution only, not under Rule 65.
This expanded certiorari power of the Supreme Court, Your Honor.
Okay, so you're saying that it will fall under the ordinary certiorari power of the Supreme Court, not under the extraordinary certiorari power.
Well, based on Section 1, Article 8, Your Honor.
Section 1, Article 8.
Yes,
Okay,
Your Honor.
thank you, Counsel.
Justice Velasco, please.
Mr. Solicitor General,
Good afternoon, Your Honor.
I've asked this question to the petitioners. I would like to ask them again. What is the quantum of evidence that the court should utilize in resolving this issue of whether the factual basis, or if you can say alleged factual basis, in the Proclamation 216 are sufficient? What kind of quantum of evidence? Will it be proof beyond a reasonable doubt, substantial evidence, preponderance of evidence, clear and convincing evidence, or substantial evidence? Or as one of the petitioners pointed out, it may be more than evidence to justify the finding of probable cause.
My answer to that, Your Honor, and I respectfully submit that the quantum of evidence should be reasonable belief, Your Honor, because the President has that constitutional presumption of regularity already in his favor.
Can you repeat that again? What kind
Reasonable belief, Your Honor.
of reasonable belief?
Yes.
Will that
That
be
there
the
is
same
sufficiency.
as substantial evidence?
No, Your
relevant
Honor.
Evidence as a reasonable mind might accept as sufficient to form a conclusion? Will
It
that
is
be
somewhat
the same?
it is somewhat similar to probable cause as Justice Carpio wrote in his dissenting opinion, Your Honor.
Okay, so
But
that
it
will
is
be
a
your
little bit
position.
lower than that because of the constitutional presumption of regularity, Your Honor.
Okay, so that's clarified. And again, so I was out of the room unfortunately, but I heard that you said that there is not much difference between the calling out power of the President based on the ground of, say, rebellion, and the power of the President to declare martial law based on the ground of rebellion.
Well, the basic difference, Your Honor, as I mentioned and agreed with our learned justice, is that under martial law, the AFP is used to keep the peace in order, unlike in the calling out, Your Honor. So they will have
Isn't
police
that
powers,
also
Your
a
Honor.
part of the power of the President, the calling out power of the President to prevent lawless violence? And the duty or the power to maintain law and order is already included in the power to prevent lawless violence. Do you agree?
Well, the nuance is that if it is just mere calling out, Your Honor, usually what is used is the Philippine National Police to keep peace and order. But under the state of martial law, Your Honor, the President can call now the military, the armed forces of the Philippines, to do or to help in the peacekeeping operations, Your Honor. Just
Well,
like what happened here in
Justice
Marawi.
De Castro, I think, made a distinction
Yes, Your
to
Honor.
the effect that a declaration of martial law would include the power or an order to the military to assist in the maintenance of law and order.
Yes, Your Honor.
And I think in David versus Arroyo, the court said the declaration of martial law is a warning to citizens that the military power has been called upon by the executive to assist in the maintenance of law and order.
That's right, Your Honor.
That is the explanation of the High Court.
Yes, Your Honor.
Under the 1973 Constitution, warrantless arrests were allowed, correct?
Yes, Your Honor.
The power to arrest without warrant is included in the martial law declaration.
In the
Under the
1973.
1973.
Yes, Your Honor.
Yes, prior to the 1973, under
I-
the martial law regime. However, now, you cannot implement a warrantless arrest under the 1987 Constitution when there is a declaration of martial law, correct?
Well, Your Honor, since rebellion is a continuing crime, he can be arrested, Your Honor.
You mean to tell me the military can
Yes, capture this.
can implement a warrantless arrest under pursuant to a declaration of martial law under the 1987 Constitution,
Provided the crime is rebellion, Your Honor.
provided the crime is rebellion?
Yes, or incident thereof.
Can you explain that in your brief? Because
Yes, Your Honor.
there, I think, is a provision that says even during the declaration of martial law, the civil and political rights of citizens are not curtailed or are not affected or prejudiced by the declaration of martial law. And likewise, the power to implement warrantless arrests are not included in that power.
Well,
Can you explain that in your memorandum?
Yes, Your Honor.
That's why I went back to the question of what really is the difference between the exercise of the calling out power of the President based on the ground of rebellion and the declaration of martial law based on the ground of rebellion also. And it will appear that there is practically not much difference, except for that warning to the community pursuant to the the decision of the court in David versus Macapagal Arroyo, that a declaration of martial law is just a warning to the community that military power has been called to assist in the maintenance of law and order.
That's correct, Your Honor.
And I was asking you if that duty to maintain or assist in the maintenance of law and order can already be included or subsumed in the power under the calling out power of the President to prevent lawless violence. My point is practically there's not much difference between a calling out power of the the exercise of the calling out power of the President and the martial law declaration. Would you agree?
Yes, Your Honor. In fact, earlier on, I said it is the statement with exclamation point, Your Honor.
Yeah, that's right. And you appear to be correct there because the Supreme Court said that there are three extraordinary powers of the President, from the more benign to the less benign. And more benign would be the calling out power. The second will be the suspension of the writ of habeas corpus. And the third is the declaration of martial law. So you might be just correct in your description of these powers or the difference, or not probably difference, or lack of or similarity between the calling out power and the martial law declaration power of the President. You are familiar with the ruling of the court in IBP versus Zamora? This was the order of President Estrada on the Marines to help to suppress the spate of killings and kidnappings in Metro Manila, and that was questioned. This was considered to be an exercise of the calling out power of the President. And what was the appropriate remedy declared by the Supreme Court in that case?
May I quote, Your Honor, in IBP versus Zamora, this is what the Supreme Court said. If the petitioner fails, by way of proof, to support the assertion that the President acted without factual basis, then this court cannot undertake an independent investigation beyond the pleadings. Besides, the absence of textual standards that the court may use to judge necessity, information necessary to arrive at such judgment might also prove unmanageable for the courts. Certain pertinent information might be difficult to verify or wholly unavailable to the courts, especially now, Your Honor, that the Supreme Court has a 30-day deadline to resolve this, Your Honor.
Okay. In the light of your position that there is not much difference between an issue on the calling out power of the President and the declaration of martial law, is it your position that any petitioner or any citizen challenging the sufficiency of the factual basis of a martial law declaration should also present or allege evidence or proof
Yes,
that
Honor.
the exercise of the power to declare martial law is not proper and founded on sound basis or evidence?
Yes, Your Honor, they have to because they are the ones alleging, and therefore they must prove it.
And you would also agree that it is the power of the Supreme Court under Section 1, Article 8 on the expanded certiorari power that is the appropriate proceeding that is referred to in the Constitution?
Yes, Your Honor, in the absence of any applicable rule under the rules of court.
Are you also saying that we should follow the ruling in IBP versus Zamora with respect to the issue on the calling out, on the validity of the calling out power of the President? If the petitioner is not able to adduce or point to any proof or evidence that the exercise of the calling out power or the exercise of the martial law, declaration of martial law is not supported by evidence, would you
Then-
agree that we should apply the same ruling to these pending petitions now? Because as you said, there is not much difference between the calling out power of the President and the power to declare martial law.
My submission is, Your Honor, the IBP versus Zamora can be invoked in this case, Your Honor, and the Supreme Court may use this also, Your Honor.
Okay. But would you also agree that the difference between a petition involving a challenge on the exercise of the martial law power of the President and that of the calling out power of the President is that there is an explicit provision in Article 7, Section 18, that the Supreme Court may review the factual basis, the sufficiency of the factual basis of the martial law declaration. Don't you think that is the difference in the procedure in challenging an exercise of the calling out power and the declaration of martial law?
I agree with you. Yes, sir.
So it all boils down to that factual issue actually, whether the President had ample or sufficient factual basis to declare martial law. Okay?
Yes, Your Honor, and that is the least mota of this
And it's
case.
your position that the President has stated in the Proclamation 216 ample or sufficient factual basis in his declaration of martial law.
Yes, Your Honor.
Okay, that's all, Chief.
Justice De Castro.
Back to the issue of the difference between the calling out power of the President and the declaration of martial law. I noticed that the President has issued arrest orders, 2 arrest orders. And this is addressed not only to the PNP, the NBI, Philippine Coast Guard, the Bureau of Immigration, but also to the Armed Forces of the Philippines. And there is no court order for the issuance of this warrant of arrest.
No, Your
Yes,
Honor, because
okay. So that means that under martial law, the President can issue arrest orders which will not be covered by the provision of the Bill of Rights, saying that no warrant of arrest shall issue except upon a probable cause to be determined personally by the judge. after examination under oath or affirmation of the complainant and witnesses, he may produce. So this is one difference. When martial law is declared, arrest orders are issued by the President without going through the court. And this can be implemented by the AFP. Normally, it is the court that issues the warrant of arrest, and the arrest order is implemented by the PNP. So, under martial law, this can happen where arrest orders are implemented not by the PNP but by the AFP.
Since the rebellion is ongoing, Your Honor, and since rebellion is also a continuing offense, this is an order for them to
Yes,
capture
yes.
those who are involved in the rebellion, Your Honor.
I understand that, but the investigation and the filing of the information must be done within 3 days from the
And
date
in
of
fact,
the
those who
arrest.
were arrested under this order,
So,
there is an inquest proceedings, and the DOJ will investigate. And if there's a probable cause, they file cases, Your Honor,
Well, these are
to the courts.
this can happen under martial law.
Yes, Your Honor.
Chief, just one question. Just one question, Counsel.
Yes, Your Honor.
We're tackling now 3 consolidated petitions.
Yes,
One
Your
of them is the petition of Congressman Lagman. Together with him are Congressman Alejano, Congressman Villarin, Congressman Briones, Congressman Bagilat, and originally Congressman Dasa and Erice were also petitioners. But because Congressman Dasa and Erice were unable to sign the petition and the certification on verification and forum shopping, we dropped them as petitioners of this petition. So in your opening statement, I'm wondering why you're still insisting that because of this technical infirmity of the petition should be dismissed. The 2 congressmen are no longer petitioners. So why do we have to still, why are you still insisting that this petition be dismissed?
Well, Your Honor, first of all, in their petition, the names are still there, Your Honor. But in the verification and certification,
They have not signed.
they have not signed it. Okay.
And that's the reason why we dropped them already as petitioners. So why fault the remaining petitioners for the Congressman Dasa and Erice not signing the petition?
Well, Your Honor, if they wish to obey to the letter the rules of this, the rules of court and the other issuances of this court, they should have retyped or edited their previous petition, cancel the names of these 2 congressmen, so that they will follow the rules, Your Honor. But they did not.
That's
So-
the reason why we already dropped them
Yes, Your
as
Honor.
petitioners. So in effect, that's
However,
they're no longer petitioners.
but aside from that blunder, Your Honor, this pleading was signed on June 3, 2017, but in the verification and certification, this was signed on June 3, 2016. So it's not accurate, Your Honor. It was signed 1 year before they filed this case, Your Honor, based on this, their pleadings. And also the professional tax receipt of the notary public. So we have argued this and discussed this lengthily in our motion to dismiss, Your Honor. So we hope that you will consider it.
We have taken note of your opening statement and your answer to my questions now. Thank
Yes,
you,
sir.
Counsel.
Thank you, Your Honor. Thank you.
Justice Velasco.
Solgen, Mr. Solgen,
Yes, Your Honor.
one or two questions. This is a takeoff from the question of Justice De Castro. So there was an arrest order number 1 issued by the martial law administrator directing the arrest of the persons listed in the said arrest order number 1. Do you consider this an arrest based on the continuing offense of rebellion and not as a result of the declaration of martial law?
Well, actually, I consider this as capturing these fleeing rebels, Your Honor.
So a rebellion can be a continuing crime.
Yes, Your Honor, it
And
is.
under the rules, anybody, even a private person, can arrest or implement a warrantless arrest.
Yes, Your Honor.
Okay, that's all. Thank you, Chief.
Justice Leonen.
I'm sorry, I forgot a few points, just to help out in the discussion. The first set of points is set of questions is about the difference between the sufficiency of facts as used in a court proceeding and the sufficiency of facts as used by intelligence to inform the commander-in-chief or to a military command. So, isn't there a difference between the facts used in preliminary investigation and in trial or in any other proceeding before a court of law and the facts that are used by intelligence operatives to brief the commander-in-chief as to a something that is urgent?
Frankly, Your Honor, I don't follow your question, Your Honor.
With the courts, the evidence must be presented physically. The authentication of the documents must be done through a ritual of marking and then looking at the sponsor for the authentication. But for intelligence information, the intelligence operatives need to undergo a certain way of validation, let us say a deep penetration agent, a human asset on the ground, photos of a drone, and piece together the information without actually doing the same rituals that are done in a court of law.
Yes, Your Honor.
Yes. So, therefore, may we be taken on the wrong track if we look at the rules with respect to presentation of evidence in a prosecutorial setting or in trial, such as, therefore, it may be wrong to consider arbitrariness from the point of view of probable cause or preponderance of evidence. Is it possible that what this court should do is to look at how the intelligence, how the science of intelligence looks at how their information is actually validated? Let me give an example. For if there is a human asset on the ground and it gives certain information to their control, to the one handling that person, sometimes the way that it is validated is by another source in order to validate the same facts. And if there is a triangulation of the information, then therefore, sometimes they classify the evidence as A1 or I don't know what other classifications there is. And therefore, what this court should be looking at is whether the facts in intelligence given to the president was actually vetted through that procedure rather than an arbitrary burden called probable cause.
I think there is a standard operating procedure in intelligence gathering, Your Honor.
Yes, and actually it's a science. It is part of security studies.
Yes,
that
Your
you
Honor.
do not rely. I think what comes to mind immediately is that incident where America was led to war on the information that there were weapons of mass destruction in Iraq. And later on, they found that some of the intelligence information was not correctly vetted. And therefore, since this court is given the power to determine the sufficiency of facts, then therefore the facts provided to us must be seen in the light of whether it was actually collaborated or vetted in accordance with the science of intelligence. Is this not correct? In order to allow the proper leeway to the Commander-in-Chief, because the Commander-in-Chief will not take a document and have it authenticated. The Commander-in-Chief has to rely on whether the information has been vetted through intelligence services. Am I not correct?
Well, Your Honor, insofar as the President is concerned, I cannot second-guess him, but he has sources of information and intelligence.
Yes, precisely.
So, whether that was the SOP was applied, I don't know, Your Honor. But one thing I'm sure, he had reasonable belief to believe that rebellion existed in
for
Marawi.
us to share that reasonable belief, perhaps what should be shown is that the SOP has been followed, that there was no reliance only on a single piece of evidence taken out of context.
But that is assuming that it was taken from the intelligence info. He could have taken it from another source, Your Honor.
The other thing that I'd like to point out is there is intelligence and there is intelligence. For example, the intelligence that led the operatives to find Hapilon in Marawi was good intelligence. He was there. The intelligence that disallowed the brigade to not know that there were other affiliated members in the entire of Marawi City is not good intelligence. In other words, the way I understand it is that there is a lot of intelligence sources in our intelligence, in our infrastructure, security infrastructure. Every unit has a G2. Every regional command has a G2. Then there is NICA. Then there is the Army intelligence, Navy intelligence, etc. And therefore, I think that when we look at the intelligence that is given to us, should it not be proper that we look at the source of where that intelligence actually comes from in order for us to determine whether or not it is sufficient in order to provide the facts upon which the President acted for the declaration of martial law?
The only problem there, Your Honor, is the military may not want to burn out their sources, Your
That's
Honor.
why we can have a session in camera. Maybe not burn out their sources, just indicate where the sources are, not name them, in a general area, how they were inserted, and so on and so forth. Anyway, just a point that I just wanted to share, and probably for the deliberation of the court later on. My second point is on the suspension of the privilege of the writ of habeas corpus. The power of the President is to suspend a remedy. The power of the President is not to allow illegal arrest. The power of the President is simply to remove the power of the court to inquire on a petition for habeas corpus as to the reason for illegal detention. But I do not read into the Constitution the power of the President to actually order the arrest, considering that the Constitution says that the constitutional rights are to be respected. And I think Justice De Castro read out Section 2, Article 3 of the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall be inviolable, and no warrant of arrest shall issue except upon probable cause to be determined by the judge. And there is no other officer except the judge. Am I not correct?
Well, my answer to that, Your Honor, is in the context of this proclamation of martial law. The crime is rebellion, Your Honor, and it is a continuing offense. The perpetrators of the rebellion were identified in these arrest orders, and if they run, if they hide, then they are given the authority to capture them, Your Honor, because it is a continuing offense.
Which brings me to that point. Maybe this is not the rebellion that is envisaged by this provision in the Constitution, because it is the kind of hostilities where the army or the police need to detain someone in order to continue with the mission. On the other hand, if it is like this situation where there is allegedly ISIS or terrorists in the entire of Mindanao, you will end up with an order like Arrest Order Number 1, which is blanket and seems to apply throughout the entirety of the Republic.
Insofar as those involved in rebellion are concerned, those are the subject of these orders, Your Honor.
Mr. Soljan, what is the government's position? Is Arrest Order Number 1 and Arrest Order Number 2 enforceable throughout the Philippines?
Well, if we consider that rebellion is a continuing crime, then it is enforceable wherever that rebel goes.
So therefore, you have extended martial law, not only and the suspension of the writ, not only in Mindanao, but with that interpretation, you are extending it to Luzon and the Visayas, the Batanes, and everywhere where the perpetrators may be found.
As I said, Your Honor, the rebel carries with it the onus of rebellion because that is what he was charged with. So if he hides in Tuguegarao and a private citizen knows that he was part of the rebellion, even a civilian can arrest him, Your Honor.
But what is strange here is that this concept of continuing offense as a doctrine emerged as a result of a case called Umil versus Ramos during the martial law days. In Umil versus Ramos, the Supreme Court held that there can be arrest in flagrante if the person is a rebel, even though overtly that person is just drinking coffee. Because once a rebel, always a rebel. Therefore, removing the protections that are given in warrantless arrest. And the strange thing about this is that the President has said, President Duterte, that this is not a martial law of Marcos. This is martial law Duterte style. But yet, it seems that your interpretation of the arrest order is founded on a interpretation of a martial law jurisprudence.
Well, unless and until that jurisprudence is changed, Your Honor, we will obey it.
And the court that can change it is this court, correct? Because the President said this is a different martial law.
It will be the Supreme Court that will clarify this, Your Honor.
Thank you.
Not necessarily this court, Your Honor.
Oh, is there another Supreme Court
Well,
besides this court?
No, Your Honor, supposing in future cases that will reach the court,
And I,
maybe at that time there will be retirees already. So
and I do hope that I am still part of that court.
yes, because the lis mota remains to be the determination of the sufficiency of factual basis,
But it is better to engage.
not the arrest, Your Honor.
But I
The
think it is-
declaration of martial law.
Yes, but I still think it's better to engage the wisdom of this court because I know the particular members of this court, and indeed, they are as wise as any future Supreme Court. Thank you, Mr. Solís.
Thank you, Your Honors.
Mr. Solicitor General, much of your statements have been reassuring, no? And we take comfort from the fact that in response to the question of Justice Velasco, you said that since rebellion is a continuing crime, the rules of court provide the authority for the arrests to be made. Is that how I understood your concurrence with Justice Velasco's?
Yes, Your Honor, and the jurisprudence of this honorable
And
court.
jurisprudence that you say are still there in our jurisprudence books. In which case, since the jurisprudence is there and the rules of court are there, martial law is not necessary for the arrest of those who are charged with rebellion in connection with the conflagration in Marawi.
Well, actually, Your Honor, this arrest order is just to tell those who are the arresting officers about these persons who are part of the rebellion.
Yeah, so it's an information broadcast that you are saying that in accordance with the rules that will allow those who are participating in rebellion to be arrested, we are hereby naming them, authorizing anyone who sees them to arrest. Is that your position?
Yes, Your Honor. This is better that we have a document rather than we say it by word. You just arrest this person without the list, Your Honor.
And of course, therefore, you say that this is compatible with the third paragraph of Article 7, Section 18 again, which says that martial law does not suspend the operation of the Constitution. It does not supplant the functioning of the civil courts, nor, because the Constitution still guarantees the Bill of Rights to
Yes,
citizens, because the rules of courts authorize their arrest even without a court warrant.
Yes.
That is the basis. It
Yes.
is the rules of court and jurisprudence, and not the declaration itself.
Correct, Your Honor.
Because the declaration does not confer additional powers to the President that are not found in the Constitution or are even contrary to the Bill of Rights, and rather the arrest orders are just by way of information.
Yes, to inform the troopers
That these are the persons-
to be on the lookout for these rebels who may have already fled Marawi City, Your Honor.
Okay. So, is there any further question? Justice Hardeleza?
Be allowed to ask questions tomorrow?
So
This
I-
is how, yes, but it is already late, and therefore there are those, of course, who will be asking questions tomorrow. But this is how we will do it tomorrow, Solgen. Kindly in deference to the very sensitive information that may be shared by Secretary Lorenzana and General Año, whom you have committed to bring tomorrow. And I read from the news that, in fact, the press statement of the AFP spokesperson is that they will be coming tomorrow. Is that we are open to having an executive session with you first, together with Secretary Lorenzana and General Año. And then you will then convey to us the extent of the confidentiality that you will be requesting the court to confer on the information that you will give. And in that same appearance in executive session, which we will do in the session in the conference room, you will inform us who you are amenable to agreeing to attend that executive session, whether petitioners' counsels will be accommodated in that same briefing or not. Please give us the reasons why there should be restrictions, and then afterwards we will convene to deliberate on your manifestation. That is assuming that you will make those qualifications tomorrow.
yes, Your Honor, I will inform those resource persons, Your Honor.
And in connection with our standing order for the production of documents, and we thank you that you have very promptly given us copies of arrest orders 1 and 2, as well as the Secretary of Justice order relevant to the investigation of the NBI. We will also request that you convey to Secretary Lorenzana and General Año that if there are documents in their possession that fit the description of operating guidelines or instructions regarding the implementation of martial law, they will so also kindly provide us with those copies, of course, under the necessary confidentiality precautions that you will convey to the court.
Your wish is my command, Your Honor.
Thank you very much, Solicitor General Calida, and I hope that you will still remain friends with Congressman Lagman. So with this session is in the meantime adjourned to resume tomorrow, 10 a.m. First, the Solicitor General will appear with Secretary Lorenzana and General Año to make a proper manifestation before the court. The counsels for the petitioners are hereby required or advised to be on standby, depending on the outcome of such manifestations. This session is hereby momentarily adjourned.
Thank you, Your Honors.